Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Utah versus Kouri Richins. We are in day 11 of the trial in which Kouri is accused of poisoning her husband, Eric. And get settled in, get comfortable, and let's get started. All right, welcome in everybody. Day 11 of Utah versus Kouri Richins. Hope you guys are doing well. Let us see who is with us today. Let me scroll on back, see if I can get back to, let's see, we got Ed Ginn, we got Squid Kid, Anthony, good morning to you. Downey Lynn, yes, I am the Squeegee of Justice, and I go by Chris as well. Kimbers, good morning to you. Awesome that you are with us. Dove, I like this chat because people are not rude. Well, we appreciate that, and we aim to make this a courteous, respectful chat, and we hope that you enjoy many trials with us. Kimbers, welcoming in everybody. Kathy, good to see you. Beach Mom, good morning to you. Squid Kid, yes, game over for Kouri. We'll see. Yeah, if you guys haven't taken the poll, I guess you have to as you come in. Take a moment and answer our poll. Has the state met their burden? Rock and roll, good to see you on the way to the tax man. Linda, good morning to you. Hellrider, good to see you as well. Thank you for joining us. Good vibes only. Richard in the kitchen, good morning. Allison, Green-Eyed Cat, hello. Taco Tuesday, you guys. Kathy Davis, good morning. Brown-Eyed Girl saying good morning to everyone as well. All right, Jenny G, welcome in. Wizard, good morning. Hello, I missed you, but I'm ready for another day of trial. Carol, good morning to you. Seagate, good to see you. Let's see. JMS, good to see you. Welcome in. Mally, good morning. Dream Horse, good to see you. Heidi, good morning. Lazy Boys, yes. C&E is Cody and Eric. Iowa Backyard, good morning. Nana, good afternoon to you. Heidi, 3:15 for you. Understood. Hector's mom, good morning. Amanda coming in and saying hello. Good to see you. All right. Katie. Hello. Good morning. Welcome in. It is going to be spicy, Hellrider. It's going to be Detective O'Driscoll will be on the stand probably pretty much all day. Stella, good morning to you. He doesn't need law enforcement to babysit him, lazy boys. Yeah. Mr. Gabler was quite the character yesterday. Linda, good morning to you. Kathy. Kathy and Kathleen. Ionine. Sharon, good morning, good morning. Welcome in. Betsy, good to see you. Watch out for Super Ball, the killy kidder, the killer kitty. All right, yeah, let's we have a feed already. So once again, I want to thank R.A., Scott, Recovery Addict. This is his Top Mark Media channel that he is providing the feed for us. So I want to thank him for that, even though we have a spinning wheel. But let's see. Let me put us over here. So the jury's not going to come in for another hour, but the lawyers are going to hammer out what is going to happen today with Detective O'Driscoll. So he's bringing in these jail calls, right? And I'm assuming, and I could get into trouble for that, the walk the dog letter, right? Because we have yet to we know all about the walk the dog letter, but we haven't actually seen it. It hasn't been brought in yet into evidence. So let me just make sure. All right, so Scott is live. Let me just, no spinning wheel there. Let's see, why do I have a spinning wheel here? All right, let me refresh this feed because I don't want us to miss anything. So the attorneys are coming in, the parties are coming in early. Okay. All right, we're good. All right, now we're up and running. All right, cool. Again, thank you, Recovery Addict, Top Mark Media. If you guys are not familiar with Scott, please go check him out. Why do I have a spinning wheel? He doesn't have it over here. All right. I guess it just pops up every once in a while. All right. So today, attorneys, both parties are coming in early to go over Detective O'Driscoll's transcripts of his jail call, of Kouri's jail calls, and then I'm hoping the walk the dog letter. He was is the lead detective. He took over for Jamie Woody. Jamie Woody was the lead detective at the beginning of this investigation, and then Detective O'Driscoll took over. I also want to find out, he had kind of a run-in with who was it? Anna Isbell. She was the 18th witness, and she said that he came over. He I guess he wanted her to come in and testify, and he was saying, next time I come over, I'm going to have a warrant, and I'm going to bring a pole to catch your dog. So he didn't sound like he was very nice to her. Let's just put it that way. So I hope that's not his mentality. I hope he's a nicer detective than what Miss Isbell portrayed him to be. Hey, Ola, good to see you. JPC, Miss Baba Yaga. Turns out you're deeply invested in this one. Sherry, good morning. Ed Gein, good to see you. Just a Girl Baking, welcome in, welcome in. Just want to make sure I see everybody here. I think I got everybody. Gina, good morning to you. Nan, welcome in. All right, I think I got everybody. So yeah, yesterday, my goodness, yesterday was really, really interesting. Just when I thought, this trial still has its fits and starts, right? I was thinking about that today while I'm, just going about my morning routine and everything, and I'm like, this trial had a lot of high hopes, and it's delivering. I think it's delivering, but there was also it just seems like if I may complain about it, please indulge me in my complaint of that. There's a lot of objections, right? There's a lot of objections. It's like just when it gets started, it's like objection, and then the sidebar, and the sidebars aren't like 30 seconds. They're like 5 minutes, 10 minutes. Sometimes the jury has to leave, and that to me is just like it's just a lot of fits and starts and stops and very herky-jerky. So it's not the easiest trial in that regard to watch for me, and this is just my own personal opinion. I like trials that are a little bit more smooth. I don't mind a sidebar here or there. Of course, they are necessary and part of trial. This one just seems to have an overabundance of sidebars. And I'm going to do a quick find. Let me see. I have 43 sidebars, and I know there's been more than that. Let me see if I can find objections. Let me see how many objections there have been. 92 objections, and I know I didn't get all of them. Now that doesn't mean that, okay, so now I'm saying they're not always just objection, boom. So it's within the context of the trial as well. But that's a lot, right? That's a lot. 40 some odd sidebars. There's probably at least 10 more that I didn't catch, or 5 more that I didn't catch. So it just seems like, right, Allison, am I off on that? It just seems like some trials just run really smoothly. Hey, Shirley Roth, good morning. Joanne Jedi Platypus, vacation mode is activated. Awesome. Oh, enjoy yourself. Please enjoy yourself. Little Lulu, hello to you. The rhythm is off because of snide bars, right? I mean, and I get it. I mean, it's part of trial watching, I guess, but I just feel like some trials we watch just go really smoothly, and there's like maybe two objections or 2 sidebars, or one a day, if you will. This one, it's like sometimes it's like literally every sentence there's an objection to, and then a sidebar. And it just seems like a lot of this to me could have been worked out in pretrial hearings. I thought that they did do we did a lot of pretrial hearing watching. I thought they did hammer out a lot of these issues, but it just seems like I don't know. It's making for difficult trial watching, in my opinion. So, Sam, how are you? Not a fan of the defense. Elaine, good morning. Debbie, good to see you. Welcome in. Let's see, JMS, you were thinking Kouri wouldn't testify, but I may be changing my mind. She strikes me as quite the narcissist and may want to testify. I may be wrong, but who knows? I think he covered all bases there. I would love to see her testify, of course. I think whenever a defendant gets up on the stand, to me, that's a perfect ego takes the stand episode, which we are looking for. We've got at least 4 or 5 from last year alone. Nick Casotis, of course, and now we have Colin Gray. But in that Banfield, the au pair trial, we still have to do him as an ego takes the stand episode. Will Kouri take the stand? We'll have to ask that question next. After this poll, I'll end this poll at noon, and we'll ask, because state theoretically, well, not theoretically, they are resting after this witness. So will they rest today or not? That's going to be the question. Will O'Driscoll get through today, or will he get carried over into tomorrow? Hey, Raj. Good morning to you. Kimbers with the 5 Trial TV Live gifted memberships. Thank you so much for that, Kimbers. Squid Kid, you got one. Downey, awesome. I love it when people in chat get gifted memberships. Fantastic. Maple Craze, Boise. Awesome. I love it. Fantastic. Good job, Kimbers. You got 2 of them. Downey and Squid Kid. Awesome. Come on down. Hey, little Lulu, good to see you. Where is this walk the dog letter, Jennifer King asks? It has to be O'Driscoll. It's got to come in, right? It has to come in. There you are, Squid Kid. Squid Kid receiving. And see, Downey. Amy, good morning to you. Good to see you. Fanny, oh, there you are. Good to see you. I see people saying hello to you. I didn't see you. Yes, come on down. There you are, Downey. There you are. Got a membership. I love it when you guys are in chat and you get gifted memberships. That's the best. Jennifer, I did not find this princess letter. What do you call it? Baby cakes? I'm guessing that's something that Eric wrote. I'm thinking. Or did Kouri write that to Eric? Not quite sure. Hola, we have no proof yet that Kouri gave any pill to Eric, slyly or otherwise. That is true. Hey, CCG TV, good morning to you. Ambi, good to see you. Thank you for joining us. Hola, that is true. And we never will. We never will find that evidence. That evidence does not exist other than in Kouri's mind, one way or the other, or Eric's mind, one way or the other. I guess now that he's on the other side, he might be able to determine what happened to him. If you believe in that, Eric's saying, "Hey, I know exactly what happened," and the only person that knows that is the person who did it. Here's you have to break it down. Eric offed himself, right? Eric took his own life, right? Which seems highly unlikely, but it's possible, but not probable. So Eric took his own life. Eric was taken out. Somebody did it to him. And if you think that, then who? Certainly wasn't the kids. Probably wasn't at a party, right, where somebody would do that to him. So the only other answer is Kouri. So either he did it himself, Kouri did it, or it was accidental, which again is possible. But there's really no evidence that he was into that kind of stuff. Yes, he would take THC gummies, but that stays in your system for at least 30 days, give or take. So there was no evidence. So even though Kouri's saying, "Oh, he took gummies all the time," no, that's clearly a lie. Because if he was doing gummies, it would be in his system, and it wasn't in his system. And it stays in your system, as we know, for a month at least. Like I said, give or take a couple days here or there. And especially if you do a lot of it, it's going to be in your, it's going to build up. It's going to build up. So you're going to have a lot of it in your system. So he did it himself. Kouri did it, or it was an accident. All right, seems like we got a feed here. Let me just back that off a little bit until we actually have. Here we go.
Okay. 231-500-139. Counsel for the state and for the defendant are present. The defendant is present as well. Sure. Spill it. Okay. Lots to cover. Ms. Nestor, I appreciate the email you sent earlier this morning. Should we start with the O'Driscoll interview?
Okay.
Does that make sense?
Yes, sir.
Okay. So this is docket 1163, which is the state's motion regarding portions of the O'Driscoll interview as clarified by docket 1555 and Ms. Nestor's email of this morning. Let me get there with you, and I left both of those items on my printer. I'll be right back. You can stay seated. Thank you.
Hey, Brittany. Are you in the mid-17? Yeah. Thank you. Oh, goodness.
All right, we just have people filing in. I was wondering if they were going to have the gallery, if this was open to the gallery. So, oh, and he's back.
Have a seat. Thank you. Okay, Ms. Nestor, with respect to pages 1 to 7, what's the value in, or I guess more accurately, under Rule 106, how do pages 107 qualify, explain, or place into context the stuff that follows?
Mainly because he gives the reason why the whole interview is happening, like what he's doing there and why the interview is happening, and from his perspective. And I believe that's important to put the whole interview into context. I don't see there's anything at all objectionable in it, and it does provide a context of how this meeting happened. They're not in the police station, they're in her house. She invited him in. She voluntarily met with him. All of that, I think, matters to context, and we're asking that it come in, especially because there's nothing in it that's controversial, and there are things that I think that are very helpful.
Mr. Bloodworth.
Your Honor, there's a distinction between context to the interview and context to particular statements. And while this provides context to the interview, it provides no context to kind of any of the 6 individual statements. The interview context can be sufficiently drawn out through examination of Jeff O'Driscoll. I mean, I'll lay a lot of some of that foundation before I introduce any of the statements, and then of course he's subject to cross on that. The other thing is this is peppered with the defendant's self-serving statements that the state holds the keys to.
Okay. So we're going to do this one chunk at a time. The standard under Rule 106, and it's not discretionary, it's an on or off switch, is whether the portions that, in this case, the defendant wants to add to the designations made by the state are necessary to qualify, explain, or place into context the portions of the interview transcript that the state seeks to introduce. That's under cases like State versus Cruz Meza, 2003, Utah 33, at paragraph 14. Here, with respect to pages 1 through 7, I'm persuaded by the state that this context for how the interview occurred will come out through direct and cross-examination of Detective O'Driscoll. These 7 pages are not necessary to qualify, explain, or place into context any of Kouri Richins' statements that follow. Okay, so we're not going to add 1 through 7. Those will stay redacted. Then we get to pages 15 to 16, right, Ms. Nestor?
Yes, sir.
Okay. This is new as of this morning. Give me just a moment. Did you have a specific line number or the whole pages?
Just the redactions that are on both pages, we would like unredacted. So it starts at line 10.
There are no redactions on those pages.
I have redactions on lines 10 through 25 on page 15 and lines 1 through 12 on 16 is the copy I was given.
Your Honor, in negotiating this back in January, the state conceded to her request to unredact that. The state unredacted it. The current copies, which are before the court and in the link I recirculated this morning, show no redactions there.
Okay. That's moot then.
Very good. That brings us to pages 29 to 32.
Because we want to use those versions that he said this morning.
So here we have Ms. Richins making references to Eric going to jail and Cody's involvement in that situation. Ms. Nestor, why is this necessary to qualify, explain, or place into context Ms. Richins' statements in other parts of the transcript?
Give me just 1 second, Your Honor.
Sure.
So, previously, they were talking about whether or not Eric was happy, if he was depressed, if he was suicidal. And as a flow and arc of that conversation, she then goes into the question O'Driscoll asks is, okay, anything else regarding his mental health history? That's line 3 on page 29. She answers, no, not really. But then she goes into, like, there wasn't generally, he had his struggles, he was stressed, and then she explains how he was stressed. So I think or why he was stressed about his relationship with his business partner. I do think that completes the answer to the question. It completes the entire subject matter of the conversation. It's actually evidence that has already come in as far as no longer being objectionable. This all came in Cody's testimony. So we would ask that it be put back in.
So I think you have fairly characterized everything through page 31, line 3. After that, though, I think he turns in a different direction. That is not relevant or does not qualify, explain, or provide context for what you just described.
I really don't care about the rest of it.
Mr. Bloodworth, line 29, page 29, line 5 through page 31, line 3.
So we will unredact that portion now.
I think it's a fair continuation of Kouri's explanation regarding things that were stressing Eric Richins.
Yes.
Okay, very good. So we're going to unredact page 29, line 5 through 31, line 3. The remainder of that redaction stays as is. All right, I think then we go to pages 107 to 112. Help me out, Ms. Nestor. I wasn't quite following defendant's position on this.
Okay, just 1 second, Your Honor. I'm sorry. So this, and it's getting hard for me to remember what I know from what happened in the courtroom versus what I know from getting ready for trial, so I apologize. I cannot remember if this came in yet. I think it's going to come in with Mr. O'Driscoll if it hasn't already with Chelsea, but there's conversations in here about texts with Chelsea on the day that Eric passed. And it's a continuation of O'Driscoll asking about phone records and him reviewing available phone records. And she goes into what she's reviewed in terms of the calls between her and Chelsea. So I do think it's all part of one conversation. Let's see. And I think to the extent that hasn't come in yet, I think it's going to come in today.
Well, I don't disagree with your prediction about what Detective O'Driscoll might testify to. The task I have to engage with here is whether any portion of 107 through 112, line 9, is necessary to qualify, explain, or place into context Ms. Richins' other statements in this interview.
So I think it's a direct continuation of the questioning above it about telephone records and whether
Right.
she has available phone records, and she discusses these records of calls with Chelsea. So I do think it's all one conversation.
Can you point me to specifically? It seems to me that in the preceding pages they're talking about what phones she had access to during what periods of time, when those devices were or were not available to her, which belonged to C&E, which belonged to her.
If you go back just a little further, Your Honor, to page 105, line 15, Detective O'Driscoll starts with, okay, so when was the last time before the night of the 3rd that you talked to Chelsea? Do you think it was the 2nd? And she says, I think it was the 2nd. And he says, when you guys were talking about the anniversary, do you know for sure if it was the 2nd or 3rd? Kouri goes into, well, yeah, because actually she sent me all the text messages because they were saying Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely not true. And that there was some kind of message or something the night of the 3rd. I don't know, but we've pulled all phone records, and Chelsea still has messages on her phone. So none of that is accurate. And then it goes into, do you have those records? They were talking about subpoenas. Do you still have them? And then they start redacting her explanation of how she got these texts and basically that she's looked at them and what they say. So I think you're cutting out the second half of that conversation, which to us is misleading, and we'd like it all in.
Your Honor, may I offer a suggestion?
Yeah.
The state proposes to redact page 105, line 15, all the way down through 107, line 11. So redact the entire portion as it relates to Chelsea Barney.
Okay. That removes the necessity of what follows, Ms. Richins. Ms. Nestor.
It does, except that I think they'd have to go back further because they still have up there where Detective O'Driscoll's basically saying it's weird that your conversations with Chelsea's are deleted. So, I mean, they're just picking the part they like and taking out all the rest of it, right? So they'd have to go back further. If they really want to take out everything about this, it would eliminate my objection, but they'd have to go back to, let's see.
So why don't we go up to 105, line 3?
Okay, let me look at that.
The state still gets the general question on page 104 into 105. It just doesn't focus on Chelsea.
That would fix my objection because then it would just take all of it out.
Well, yeah.
For example, just so the record is clear, because we only have an audio record here.
Sure.
We have Detective O'Driscoll asking about whether is it possible that things were deleted on your phone? And Ms. Richins saying at 104, line 20, yeah, that's just not possible.
Right. Right, and then he gets into Chelsea starting on page 105. So, right, if they would delete from 3 of 105 all through all of it, then that eliminates my objection because then they're not just putting in half of it and not the other half. But I would withdraw my objection under those circumstances. But if they want half of it in, I want all of it in.
Well, Okay, Your Honor, I think we're narrowing in on this, but I don't think we're there yet.
Okay.
I think the defendant raises Chelsea, right, at page 105, line 8. It wasn't Detective O'Driscoll. So I think the redactions should begin
Oh, I see your point.
at
Line 15.
line.
She's using recovery of information on Chelsea's phone as an explanation for why she wouldn't bother to delete anything.
Correct.
Okay.
And I think
So-
there's a distinction between, right here, I think at line 15 is the tipping point where there is a statement about deletions,
Right.
and then at line 15 it tips into a discussion about text messages with Chelsea in particular.
That's fine, Your Honor, if you want to start at line 15.
Okay, so we will add the following redactions. We will redact line 105, page 105, line 15 through 107, line 11. And that resolves defendant's request to unredact pages 107 through 112, line 9. Scott, I went kind of fast there. Did you get that?
Yes, Your Honor. We have someone else listening in.
Okay, very good. All right. Anything further on that, Mr. Bloodworth?
No, sir.
All right. Through 107, line 11. All right. That brings us to page 120. Line 24. To 121, line 8. This is Kouri Richins giving Chelsea's phone number to Detective O'Driscoll. I didn't follow how this relates to a prior statement.
Just 1 second, Your Honor, I'm sorry. So all this stuff above that is redacted, right? Are you looking at it?
Yeah.
Okay, just a minute, I'm trying to... through line 121, line 8. I'm sorry, I'm getting a little bit lost. Just let me look at my notes that I did just one more time. So right now we're looking at the 120, line 24 through 121, line 8.
Please.
Okay, I got it. Just 1 second. This may not apply anymore now that Chelsea's testified, but let me just make sure. We'll withdraw that one, Your Honor.
Okay. Then let's go to page 125, lines 6 through 16. I genuinely don't know why defendant wants to unredact this. We have worked real hard to keep this out.
Yeah, we'll withdraw that one.
All right. Then we go to page 133. Beginning at line 12, and it goes through 141.
Okay.
My notes reflect that this is a discussion regarding law enforcement officers and Kouri Wright taking all computers related to C&E and maybe some others and Cody having access to the garage and office at the Richins home. How does this provide context for Ms. Richins' other statements in the interview?
Just a minute. I'm trying to see where their redactions start and end on either side. So give me 1 second. So is everything after 141 redacted still? I haven't seen the newest version. Everything after 141 is redacted still.
No, there's some unredacted portions beginning at page 167. The statement before this redaction that we're discussing is the defendant's statements as it relates to life insurance. The statement after this redacted portion we're discussing is the defendant's statements as it relates to the trust. And the piece that we're redacting relates to collection of C&E computers, which in the state's view under 106 is not context to either the preceding or the subsequent statement.
133, line 12 to 140. That looks accurate based on my review, Ms. Nestor.
I think most of this has come in now, so I'm just making sure that there's nothing. I'm almost there. 1 more second.
Take your time.
That was quite a few pages. That's all come in, Your Honor. We don't need it anymore.
All right. So defendant's request to add pages 133, line 12 to 141 is withdrawn. Then we fast forward to pages 174 through 184. Here, Ms. Richins is talking about the parties' joint account and the flow of money from C&E and her real estate business through various accounts.
Right.
The immediately preceding statement is regarding the trust. The immediately following colloquy seems to be about life insurance policies.
Yeah, just a minute. So this is 10 pages. I also think most of this has come in. If you can give me just a moment, Your Honor.
Sure.
No change in all that. Well, there is no break at 141. The redactions continue until 1. There's no change.
I think that all came in, Your Honor. We'll withdraw that one.
All right. And then finally, page 213, line 25 through 215, line 6. This immediately follows a statement by Ms. Richins regarding Eric knowing about the HELOC and consulting a divorce attorney, and him knowing about that based upon statements made by his family members. I'm not sure. Forgive me, I misstated that. It immediately follows a statement by him about knowing about the HELOC, and then Ms. Richins talks about how he knew about that was because his family members told him, and then he went and consulted with a divorce attorney.
Right. I do think that's all one conversation, Your Honor, where they're talking about how he I got to go back a little further. They're trying to say what they're accusing her of and how they changed I mean, that's all one conversation, I think. I stand on that request.
Tell me why Ms. Richins doesn't pivot away from what Eric knew to what his family members were doing to her. There seems to be two different topics here.
Well, I think this is all connected to the HELOC. I mean, Ms. Benson testified early on in this case that the HELOC was what precipitated the meeting with the divorce attorney. The divorce attorney has also testified to that.
Right.
This is Kouri lumping all that together in one conversation with O'Driscoll. So I do think this all should come in context. I just think it's all connected to the beginning of the conversation where they're saying that he was unhappy about the HELOC and that he had been meeting with someone about a divorce and that Kouri was unaware of that and that she learned about that later from the family. So I think that's all connected. I would ask that come back in.
Mr. Bloodworth.
Your Honor, the preceding statement, which is the statement the state seeks to isolate, is the defendant's statement regarding what she knew about the HELOC. In the redacted portion, she then pivots to divorce attorney discussion, which is in her statement separate and distinct from the HELOC discussion. It has come out in trial that the two are connected, but in this statement, it is a distinct statement through the course of this interview.
Just in terms of ending that, Kouri Richins. Yeah, I think. It seems that Ms. Richins' sentence that begins on 213, line 22, doesn't actually end until 214, line 2. It looks like maybe she and Detective O'Driscoll talked over each other in that point. It would seem appropriate to end it there and then redact the rest. So just to unredact 213, line 25 through 214, line 3.
Agreeable.
Okay. That's the court's ruling, Ms. Nestor.
Understood.
So we're going to unredact page 213, line 25 through 214, line 3. Okay. I think that handles the parties' positions regarding the transcript of Detective O'Driscoll's interview with Ms. Richins. Mr. Bloodworth, anything else on that?
No, Your Honor.
Ms. Nestor?
No, sir.
Okay. So that brings us to the jail calls. This was originally filed as docket 1165 by the state. It's further characterized by docket 1555. We're just going to have to go through these one at a time. As a matter of mechanics, Mr. Bloodworth, these will come in through Detective O'Driscoll.
Yes, Your Honor, as a matter of mechanics, and I don't know at this point if we're going to introduce them all through Detective O'Driscoll on direct. In fact, trying to recall, there may be only one or two that I can pin down that we may want to address first, although I think that if we can, we should resolve the whole set of them today, because I can see how it would come up in either redirects or some crosses that would could begin as early as today.
All right, let's go through them. So, tab well, I don't know if you have the same binder. Let's go 2-69T.
Your Honor.
And my main concern is on page 8, lines 6 through 18.
I'm sorry, Your Honor, I'm just pulling it up. Which one are you looking at? Can you give me the number again, sir?
2-69T.
Okay, got it. And what portion are we looking at?
Well, the court's concern, based upon the content of the unredacted portions that the state seeks to admit, is page 8.
Lines 9 and 10?
Especially, yeah. Although,
Oh, that's definitely part of it. Well, that's Carmen being in jail, right?
yeah,
No, she's not in here, meaning Summit County Jail.
What jail is she in because she's not here?
yeah.
Oh, well, she's not
The only
here.
way Ms. Richins would know she's
Right.
not there is because
Right.
she's there. Yeah.
Right. Yes.
So, yeah, Your Honor, we can certainly redact line 9 and 10 there. We can even redact 11. I don't.
Yeah, if
Just
we can
to
do
be
9,
safe.
10, and 11. Yeah.
Yeah.
Okay. Ms. Nestor, what was defendant's objection to the remainder of this?
Hold on just a minute, Your Honor.
So, Brittany, from 2-69T, we're redacting page 8, lines 9 through 11.
I think that was my objection to this one.
Okay.
Let me just make sure. I think that was it. I think that was the only problem I had with that one.
Very good.
Wait, hold on. That's Carmen.
Okay.
Yeah, that's it, Your Honor. That was my objection.
Very good. Let's go to 2-71R. There's only 3 text messages sent from the jail
Oh, I'm
set.
sorry, Your Honor. Oh, never mind. They redacted it. Okay, I apologize. Please continue.
2-71R. These are text messages sent from the jail system. The state seeks to admit 3, right?
Yes, sir.
It's the ones from May 24 at 9:50, May 24 at 10:02, and May 24 at 10:03.
Correct.
Okay.
So we have a couple of objections to this one, Your Honor. It looks like they have made all the redactions that we requested that indicate it's jail-related, so that those have been resolved. However, this is a correspondence between Kouri and her brother, and the brother's asking her, did Eric ever talk about suicide?
Right.
And she's repeating things that Eric said to her, which would be hearsay. Also, I believe the brother's statements are hearsay.
Well, all of the non-Kouri Richins statements are going to be hearsay if they're accepted for the truth of the matter.
Right.
So that's
Well,
an
but
issue.
they're specifically trying to admit what Eric said for the truth of the matter. So that's the concern that I have. It's like double hearsay. I know Kouri's statement isn't hearsay, but when she relays what Eric told her, that is hearsay. So that's our objection to this one. Also, we just don't see the relevance. There's no...
You don't see the relevance of whether Mr. Richins ever spoke about suicide?
I don't think either side is making the allegation that he intentionally killed himself. That's never been said by either side.
I think the state is seeking to prove affirmatively that he did not. So I think we can put relevance aside. It's certainly relevant.
Okay.
Mr. Bloodworth, talk to me about the hearsay. Put the brothers level aside. It's the truth of Eric's statements to Kouri as related by Kouri. Kouri's level, categorically not hearsay. It's the Eric Richins level. Let me pose a hypothetical to tease out the legal issue. It'd be one thing if... I guess what we're trying to tease out is whether this is evidence of whether Kouri ever heard Eric say it versus whether Eric ever had suicidal ideations.
So I appreciate that distinction, Your Honor. She doesn't quote him, right? It's a generic, this is my impression of generally...
Of my husband.
Right.
Yeah.
Well, respectfully, I disagree. He would always say things like, if anything ever happened to me, blah, blah, blah. I mean, if they want to redact everything after the word not suicide specifically, then my objection, apart from the relevance, which I stand by, but that would cure the hearsay problem of what he actually said. But they could leave in her answer not suicide specifically, because I don't think that relates to a particular statement. It actually refers to the absence of statements.
I think the opposite. That is what explains her statement, not suicide specifically.
Well, then then none of it should come in.
Right. The statement is Kouri Richins' statement is not suicide specifically. The remainder of that particular text message is, in a sense, 106 completeness because she is explaining her statement.
Why don't we just instruct the jury that they can't accept Ronnie or Eric's statements for the truth, but they can accept them for the effect they had upon Kouri Richins and let the whole statement in?
Correct, Your Honor. That's appropriate.
Because it's not being offered to show any effect on Kouri Richins. It's being offered to get in the fact that Eric made that statement to her. That's the whole reason this is coming in. And I stand by my objection, Your Honor.
And just to be clear, you don't want to admit the statement that Eric told her they'd be set for life if he died.
No.
Okay. All right.
That's like,
guess if the statement Eric made isn't true, what relevance does it have, Mr. Bloodworth?
It explains Kouri Richins' statement, not suicide specifically. It is the effect on Kouri Richins to make this, to respond to the question of did Eric ever, whatever the question is, hold on. Did Eric ever talk about suicide? She says, not specifically, and then explains herself.
So
That's
is the
foundation for her statement. It shows what the effect of Eric's statements on her.
right? But as we tease this out, it seems that to the extent that the effect upon her was relevant, regardless of whether it was true, it was her understanding that she'd be set for life if he died, not whether or not he had suicidal ideations. Is that fairly stated?
Your Honor, the state thinks it's both, actually. It is the set for life if he died. It's certainly that, right? But it's also the suicidal ideation part because, evidence will come in that, I think evidence is going to come in that she never believed, she said he would not commit suicide in other portions of it.
And at her level, that can come in, right?
Sure, but there's a foundation for that. Why do you believe that?
I think with respect to this particular text exchange, first of all, I don't understand why we need the third one. Can we work backwards from there? Why do we need her brother saying, just curious, someone threw out a scenario, made me think? That seems to be a throwaway.
Well, I guess it all depends on whether or not DJ testifies.
Forgive me.
That statement could be used in impeachment of DJ Kouri if he were to testify.
Is this one of the things that's coming in through the state's case in chief or the rebuttal case? Or through cross? My apologies. As yet unclear.
So, yes, Your Honor, let me perhaps resolve, I think, the current tension.
Yeah.
If it comes in the state's case in chief, then I would agree that third statement we could redact. We may have a discussion down the road about unredacting it.
Understood. Okay. So focusing on the first two, I think the correct result here, let me state it and then let counsel ask for any clarification, is to admit the first two text messages with the following instruction to the jury, that they cannot consider Ronnie's statements for the truth of the matter only for the context that they had or the effect they had upon Ms. Richins as the listener. They cannot consider Ms. Richins relating what Eric Richins told her for the truth of whether he ever had suicidal ideations or whether she would actually be set for life if he ever died, but can consider it for the effect that statement by Eric Richins had upon her on a going forward basis.
Can we just get a statement as to what effect that did have on her? Because I don't understand that argument at all. And
she thought she would be set for life if he died. It provides a motive to kill him.
Okay.
Mr. Bloodworth, any clarification?
No, Your Honor.
Okay. Any other clarification, Ms. Nestor?
No, sir. We just would like a continuing objection to that one.
I don't know what you mean by that.
So I don't have to, when they admit it, I won't have to jump up. I just like...
And you don't, under
Okay.
Rule 103. Have we discussed anything further on that?
No, sir.
Okay. Scott,
Yes, Your Honor.
would you initially redact the message from Ronnie at 5:24 at 10:03? Just curious. I watched something, etc.
I think it's from DJ.
Oh, I'm sorry. You're right. That's from DJ. For now. And I can pause for a second if my description was inappropriate.
We're getting it. We're tracking it in the back as well.
No problem. Sounds good. Okay, moving on. That brings us to 272R. As I understand it, it's 5 text messages from 5/31/2023 at 7:14 to 5/31/2023 at 7:24. I think the relevant part of this, Mr. Bloodworth, is that Ms. Richins saying she hardly knew Hayden Jeffs. Is that the point of this?
Correct.
Okay. And so do we need anything after the 5:31 at 7:22 where she says that?
So you're referring to the last two of those texts?
Yeah.
We can redact those.
Okay.
Wait, I'm sorry. Which ones? I missed which ones you're talking about right then.
Another one wanting their 15 minutes of fame. Oh, God, huh?
I would object to that coming out. I object to this whole thing coming in, but if it comes in, they should all be in.
All right. Tell me why you object.
I don't understand the relevance of this at all.
So we have testimony that's come out that Kouri Richins had a telephone conversation with Hayden Jeffs regarding the topic of fentanyl. Here she's saying she hardly knew him. It's probative of their relationship.
They don't talk about that at all in here, though, about any conversation that
But
she had with
she
him.
talks about hardly knowing him.
Your Honor, we just stand on a relevance objection.
Okay, anything else?
No.
Okay. This is relevant to Ms. Richins' knowledge of or disclaiming knowledge of Hayden Jeffs. And do you want the whole thing, Ms. Nestor?
Yes, I do.
All right, we'll leave it as is, Mr. Bloodworth.
Yes, sir.
Okay. All right, tab 7. Sorry, 273T and 274T and 275T. Mr. Bloodworth, Ms. Shervinick, I am genuinely confused by these in terms of this transaction in St. George and this other deed, and I read them 3 times. I really don't know what they're talking about.
So let me propose this as a way forward.
Yeah.
To date, nothing has come in where the state would use these. I can see a circumstance where the defendant's mother would testify that the state would want to use these texts in impeachment.
Or the phone conversation.
Or the phone
Right.
conversation.
Okay.
So maybe we can just put a pin in these till if and when that circumstance arises.
I appreciate that. Any objection, Ms. Nestor?
No, Your Honor.
Okay, very good. We will skip 73T, 74T, and 75T for now. Then we go to 2-76T. With respect to this one, the defendant objects to redacting lines 2 through 8 on page 7. Under Rule 106, in the court's view, Lisa making a comment about a corrupt police force is not required to be included under Rule 106, but Ms. Richins wondering if Detective O'Driscoll didn't relate part of his conversation with her to the prosecutor. That seems to provide context.
It wasn't the corrupt police force comment I'm interested in, it's Kouri's, so I don't have a problem with that staying redacted.
So I think if we just focus, Mr. Bloodworth, on page 7, lines 4 through 8.
I also, Your Honor, while he's looking at that, I did catch on page 7, line 19 and 20. I think that's Lisa reading the information, I'm guessing. And that's the hearsay the court's done an in limine ruling on, page, line 19 and 20. On page 7, that also, just that one little part needs to be redacted. He later told his friend he thought Kouri tried to poison him. That's been kept out.
Well, that part's come in a couple of times. I think it's the sentence before that's the problem. Because that's part of what the state has to prove, right?
Actually, both of those.
I think they both come in.
Forgive me, have we gotten the detail of
the only thing that's come in...
Ate the sandwich, broke out in hives, had trouble breathing?
No.
That detail has come in, I think, in the context of, well, in Ali Staking's testimony about what they were joking about.
Yeah, certainly ate a sandwich, had a reaction. Was she that specific? I genuinely can't remember.
No.
We can... Hopefully somebody in the back scrambling right now to
take a look
to get that portion of the transcript. I also think it's coming in a text message as well.
There's the June text message, right, where Ms. Richins is, I forget who the recipient of that text message is.
Chelsea Barney.
There you go. Is talking about, they're saying I gave him a sandwich on that day. And
right, it's correct. It's the defendant saying, I was with him when he ate. I gave him the sandwich for lunch. He didn't break out in hives. He didn't use an EpiPen.
That's right. Okay.
The concern I have also is it says he later told his friend, which is Cody or Case, one of those.
He doesn't say that, and we've already got testimony that there was a conversation in which he told a group of people that she tried to poison him.
Jokingly.
Well, whatever.
This is referring to telling his friend, because his friend was not at that conversation. His friend would be either Cody or Josh, and that's been suppressed.
Yeah, I don't think that we know to draw that connection, but the jury wouldn't.
I don't think we can risk that, Your Honor. I mean, there's a reason you made that ruling. We should stand behind your ruling.
I am standing behind it. Let's take this one piece at a time. Mr. Bloodworth, line 7, can we please add in any objection adding back in lines 4 through 8?
Sorry, page 7, lines 4
lines
through 8.
Yeah.
No objection to adding that back in.
Okay, so we will remove the redaction in 2-76T of page 7, line 4 through 8. Then, Ms. Nestor, what is defendant's request with respect to lines 16 through 20?
Your Honor, all we're asking is that Lisa Darden's statement which starts at line 16, and then the next question is, when Eric ate the sandwich, he immediately broke out in hives, had trouble breathing. He later told his friend he thought Kouri tried to poison him. We're asking to redact that whole comment of Ms. Darden.
Mr. Bloodworth, the state's response.
Your Honor, I think the just as some context here, Lisa Darden is reading from, I think, it's the interrogatories in the civil case. That's why she uses the word question. The important part from the state's perspective is Kouri Richins' response there, ridiculous, right? So the preceding paragraph is necessary for the effect on the hearer. I think the court can instruct around any any hearsay problem about considering it for the truth of the matter asserted.
Okay. Defendant's request to redact lines 16 through 20 of page 7 of 2-76T is respectfully denied because that information, that Eric ate a sandwich, that he broke out hives, had trouble breathing, later told his friend non-specifically who that is, that he thought Kouri tried to poison him, all of that has already come in through other sources of evidence. That will not introduce any new information to the jury if they were to fail to follow the court's instruction that they cannot consider the non-Kouri Richins part of these conversations for their truth.
Your Honor, can I just also, while we're just making the record, we would also ask that lines 9 through 13 be redacted on the same grounds. I understand your ruling, but I just want to make a proffer that we'd also want redacted. So they're saying they're saying just a few days later, Valentine's Day, Kouri made Eric a sandwich and placed it on the seat of his truck along with a supposed love note. I don't believe that has come in. I respectfully disagree. I don't think it's ever come in. He had trouble breathing. And I just want to make a record on that. But I understand your ruling.
Okay. Let's see. I think that handles 2-76T. Let's go to 2-77T. Defendant objects to redacting the following two sections. Line 20, page 21, lines 14 through 25. This just seems to be a self-serving statement by defendant that is not necessary to qualify, provide context for, or explain any of the other unredacted statements. Why is this necessary under Rule 106?
Page 21, lines 14 through 25.
Yeah.
Let me check and see when they... We don't need that. We'll withdraw that.
Okay. Thank you. And then, same exhibit, 2-77T. Please go to page 25. Lines 2 through 16. I'm not sure why this is Rule 106 material either. It is almost entirely Ronald Darden statements with just Ms. Richins making non-substantively responsive comments.
Why don't you sit at the table? Sit here. I need your help. Yeah. So, for example, where does all the notes on what's been done so far?
Okay, I don't need anything above line 14, but line 14 is the beginning of her sentence that starts on line 17.
Okay.
So we need 14, 15, I don't really care about 16. It doesn't, I think he's talking over her, but 14 and 15 is the beginning of the sentence that they start with 17.
And what's the problem with lines 17 through 19?
What page?
This is Kouri Richins' statement.
She's saying her mother was telling her, so it's triple hearsay. It's her mom telling her what her mom read about what other people said.
Okay, and then doesn't she go on to talk about that on the following pages?
I'm not sure what you're asking me.
If we don't include lines 17, 18, and 19, we don't know what she's talking about when she says stuff showing that I bought lunch at Mirror Lake, like I didn't make any fucking sandwiches. It's context for what she's talking about
I don't think any of it should come in. I mean, it's all talking about a triple hearsay statement, and she's addressing it.
It's her making comments about what did or didn't happen with respect to the sandwich on Valentine's Day. That's
her
relevant.
Responding to what the triple hearsay statement is saying.
Well, that's fine, but the statements made by other people do not come in for the truth. Her statements are admissible as categorically non-hearsay.
So you're going to make an instruction on this one as well?
I'm making an instruction on all of them.
Okay,
that they cannot consider the statements that are made by people other than Ms. Richins for the truth of the matter asserted.
So, I'm sorry. I did not understand that you were suggesting that you're making one instruction for everything. I don't know how they're introducing these. I don't know if
I can make an instruction every single
That's
time.
what I'm asking.
Yeah, happy to.
Okay, that's...
Any other objections regarding this?
Your Honor, we don't think any of it should come in. We think it's all hearsay. We object to all of it.
You're going to have to be more specific. Do you believe that Ms. Richins' statements are hearsay?
Yes, because she is incorporating into her statements the hearsay statements that others are making about what happened in order to give her own explanation. So, yes.
Okay. Any other objections?
No, sir.
Defendant's objection is overruled. Ms. Richins responding to questions posed to her by other hearsay speakers is categorically not hearsay. The court can instruct around the possibility that the jury might consider the statements of speakers who are not Ms. Richins accepting their statements for the truth of the matter. Mr. Bloodworth, anything further there?
No, Your Honor.
Okay. That handles 277T. All right, let's go to 278T. Mr. Bloodworth, take a look at page 11 with me, please.
So, Your Honor, maybe I can head some of this
Please.
off. So, this along with, I think it's 2-90, right? This all goes to recovery of the walk the dog letter, which is entangled with a whole lot of Kouri Richins is in jail. I have a proposal.
Why is recovery of the walk the dog letter going to be an issue that comes in before the jury? I've already ruled on any motions to suppress it.
I don't think it has to.
I'm so sorry. Which number are we looking at right
Currently, we're looking at 78T and 90D.
So at the outset, from the state's perspective, in introducing the walk the dog letter, how it was recovered, I don't know that matters. But I can envision a scenario where, for example, defense the defendant has said that this 6-page walk the dog letter. It's been redacted down, but 6-page walk the dog letter was part of a 65-page fictional manuscript, and it was recovered from the middle or whatever of that manuscript, and the context of it, the context of the 6 pages is within the volume of a book. That is untrue, and we could prove that by proving how it was recovered.
Let's go in order of events, though. In terms of Jeff O'Driscoll testifying about the walk the dog letter. Go ahead.
Here's my proposal.
Please.
I would like to show Jeff O'Driscoll a copy. Is this an accurate depiction of a 6-page letter to Lisa Darden written on either September the 12th or 13th, 2023, that investigators recovered on September the 14th, 2023, from a book that was among Kouri Richins' personal possessions?
Any objection, counsel?
Rather than bringing in, so the idea would be he's not going to bring in 278T and
No, just we'll start there, and it will inform what we do with 78T and 90D.
So the way he just explained that answer, I don't know what I could object to.
Well, if you object to foundation, you're going to create a problem. So I just need to have what he's proposing is that question be non-objectionable based on foundation by stipulation of the parties.
Well, I don't plan to object to that question because I don't want to get into the fact that her cell was rousted.
Right.
So, I mean, I'm certainly not going to open that door.
Okay. So if it comes in that way, as I understand it, there's no need for the state to use 2-78T or 290D in its case in chief. Is that accurate?
Correct.
Okay. Ms. Nestor, anything further there?
No, sir.
Okay. Okay, then can we go to 2-93T? I think this is Ms. Richins talking about speaking with Ms. Bramwell and Heber.
Just very briefly, Your Honor, I think they missed redacting the word jail call on the first page on this one. If we could just make sure they do that.
On page 2?
On page 1, the cover page, up at in the heading.
Oh, I don't think we're showing any of the cover pages of any of these, right?
I think they have the dates on them, so they may.
Yeah,
Okay.
Your Honor, we did miss that. We will fix that.
My apologies. Okay, very good. So jail call 1 will be redacted from the caption on page 1. Thank you. Help me out. What is the probative value of this one, Mr. Bloodworth? And is this only one that might come in rebuttal, or is this the case in chief?
No, Your Honor, the state withdraws this one. Now that we've resolved the Bramwell issue and she's testified, this is no longer necessary.
Very good. 2-93T is moot. All right, 2-94T. Part of this is regarding the vacation booking statements. Part of this is Kouri Richins making statements regarding the vacation booking statements. And part of this is regarding the thing in Heber. Candidly, the statements or the back and forth regarding the quote-unquote thing in Heber is pretty confusing. The first part, I think, is more clearly probative.
This one also, Your Honor, they missed jail call on the cover page. If we could just redact that.
Scott, page 1 of 2-94T in the caption. Please redact jail call 2 from the caption.
Here you
Your Honor, at this point, because of the way the evidence came in, the state will withdraw this one as well. I can envision some corner cases where we might want to revisit it, but for now, let's just set it aside.
Very good. And then the video, 2-110, we don't need to offer that, right, Mr. Bloodworth?
Sorry, sir, I'm just bringing it up. Oh, no, so that went the same way as 278T and 290T.
Got it. Okay. Ms. Nestor, I think that resolves the state's docket 1165. Anything further on that?
No, sir.
Mr. Bloodworth?
No, sir, nothing on that. We recently identified 3 additional jail calls that we've redacted. We'll send those to the defense today. I don't anticipate introducing them today, but
Okay.
so we may have additional similar discussions.
Understood. And then, let's see. May I ask about the state's motion to admit redacted exhibits 8-57R through 8-63R? That is the state's designation of prior consistent statements by Carmen Lauber. May we talk mechanics for just a moment?
Yes, sir.
How are these coming in mechanically?
So, Your Honor, in questioning Jeff O'Driscoll today, I will ask him about conduct of the interview of Carmen Lauber. Ask him about the defense's question. You know, he was present when the defense questioned Carmen Lauber about certain statements. In context, do those, are those statements, fair? No. And then move to admit the various 57 through 60, whatever.
So I appreciate that the state has evidence through Jeff O'Driscoll and perhaps others that the arc of the interview, particularly the conduct by law enforcement officers or investigators and Ms. Lauber's responses thereto, are not the same as suggested by defense's cross of Ms. Lauber.
Right.
But you can elicit that evidence through Detective O'Driscoll's testimony. And to the extent you need to show that Carmen Lauber testified consistently with her direct versus the suggestions of what she said or what she said on cross, you can certainly do that. Mm-hmm. My question is, though, it seems like a lot of this is being shown the arc of the investigator's conduct rather than just Carmen Lauber's prior consistent statements. Now, I understand context matters, but do we really need all of it, is my question.
Your Honor, the state tried to narrowly tailor the amount of information. I think...
And to be clear, I recognize that we went from 900 pages down to 100-ish.
Correct.
So I understand that.
I think those 100 or so pages, narrowly tailored, are kind of the minimal amount to show the motive, Carmen Lauber's motive, that it was more, certainly there was a self-serving piece, but there was a lot more than a self-serving piece, and that she was not motivated by Detectives O'Driscoll and Maynard bullying her.
Right.
I think the full expanded 900 pages show that the best. I think the 100 or so we culled to show it enough.
Do you have these as one kind of video clip that plays from interview to interview, or will you provide some signposts for the jury as you introduce them?
Your Honor, we don't intend to publish them. We intend to make a few points from them through Detective O'Driscoll's testimony, provide them to the jury, and in argument argue something like, you heard the defense cross-examine Carmen Lauber. You heard Detective O'Driscoll's testimony regarding those interviews. You have them before you if you want to, or you have these excerpts before you if you want to dig through them and determine for yourself what the evidence proves.
Okay. I appreciate the efficiency of this. I have a genuine question as to whether I can send these transcripts back into the jury room when I'm not sending other transcripts of other testimony back into the jury room. I have some.
Your Honor, it's not testimony. It's evidence. It's an interview.
I mean, we'd have to go through the Crawford analysis to figure out if Ms. Lauber's statements were testimonial. Now, there's not a Crawford problem because she was on the stand.
Correct.
But whether these qualify as testimony with respect to the concern that providing transcripts of certain testimony would give that certain testimony undue weight when transcripts of other testimony are not provided, that I have a genuine question about. So I'm not suggesting that you can't publish.
Sure.
I'm asking whether you have to publish but not admit. But she was in custody. She was being questioned by law enforcement officers. I think there's at least a reasonable question as to whether this would qualify as testimonial, quote unquote.
I think two things, Your Honor. In some measure, that's why the state moved to admit the entire shebang. But I appreciate the need for efficiency.
Right.
The second thought I have is, to the extent that the defense wants to further cross-examine Carmen Lauber on these, or Detective O'Driscoll or Detective Maynard, they're here. We can all recall them easily.
I agree. Yeah. No, I agree with all of that. It really comes back to the issue of whether these transcripts go into the jury room. Publishing, you're right. You have the right to publish them to the extent you want to. I am not persuaded sitting here right now that they go into the jury room. So we don't have to necessarily reach agreement on that piece right now, but how do you want to proceed with Detective O'Driscoll on recognizing that they may not go into the jury room?
Your Honor, that would alter the state's direct of Detective O'Driscoll because we would end up publishing 100 pages of transcripts.
You have him as video or audio, though, too, right?
Well, right now, we only have the transcript. We were waiting. Video editing is long and expensive.
I see.
And so we were waiting to nail down the transcript to then conform the video.
Is audio easier? Do you have audio files?
What did
Ms. Shermack is saying no.
It's the video file is the audio file.
I see. Okay.
It's one.
I see.
So there's no distinction in terms of editing time between a video and an audio file.
All right. Pause there for a moment. Maybe I may be taking on more than I need to. Ms. Lewis, what's the defendant's view of this?
Your Honor, we object to these coming in this way. I think that
When you say this way, what do you mean?
by publishing any of these transcripts, I think you're correct that the appropriate way to do this would be through direct examination of Detective O'Driscoll. They can certainly ask him questions to try and rehabilitate what Carmen Lauber said.
Can ask him questions about what he said. They can't ask him questions about what she said. That'd be hearsay.
I understand, but the problem that as they see it, if I understand it, is they're trying to put forth that she wasn't influenced by law enforcement. So they can ask questions of Detective O'Driscoll about that. But putting these in, I do believe, is a Crawford problem.
Well, hold on. I need you to compartmentalize the objections here. These are being offered as prior consistent statements of Carmen Lauber to rebut a charge of either recent fabrication or undue influence.
I understand.
So, any objection under that rule?
Yes, that should have come in under Carmen. During cross-examination, it's fully within our right to pick out portions of this interview.
But you can recall her, right?
I don't think that's our job to recall the state's star witness. They had her on the stand.
I just asked you a yes or no question. Would you start there for me?
Could we recall her? Yes, that is something that could be possibly done. I don't imagine what world a defense would do that. But
and correct me if I'm wrong, you had the transcripts when you cross-examined her, right?
yes, but so did they. And the appropriate way to do it would have been to try and rehabilitate her on redirect, which would have then given me a chance to go into other statements.
They sought
during
to,
cross.
and I limited their ability to put in the whole 900 pages.
That's not how you rehabilitate. You rehabilitate by asking questions. It's not by putting in an entire transcript.
Well, you can do it, for example, by admitting prior consistent statements. And so I just need you to stay focused on that rule for a moment. I know I'm interrupting you.
Yeah, you are.
I don't understand how you think they were supposed to admit prior consistent statements.
Through testimony.
That's not a prior consistent statement. The whole reason we have the prior consistent statement rule is because the testimony goes in a different direction. Or there's a charge of recent fabrication or undue influence. And then you have the prior statement come in as substantive evidence.
Only while she's on the stand. They didn't even attempt to question her about whether or not pull out these portions to show, oh, look at, you weren't unduly influenced. Look at, you said this, is that correct, is that correct? That's how you would normally see this done. Then I could have cross-examined her. And I also want to point out that they have taken very small portions of this that leave out the portions of the interview where she is being influenced by statements of law enforcement. This makes it look like, they've cherry-picked what they want. And for example, I want to pull out the May 10th interview. I don't even understand why this would be coming in. All they've pulled out is a conversation between Ms. Whistler and Ms. Lauber that Ms. Lauber is supposed to testify before the grand jury. That's going to open up a whole door of speculation and what happened. I don't see how that has anything to do with what we're even talking about. And as I go through the transcripts, it's very much just what the state wants the jury to hear. If we're going to do this, which I think is completely inappropriate, this is a Crawford problem. This should have been brought in through testimony when Carmen Lauber was on the stand so she could have been cross-examined. They can bring in what they want through Detective O'Driscoll because we still have an opportunity to cross-examine him. But to just send back portions of a transcript that we've not been allowed to cross-examine on that point out to the jury just what they want the jury to hear is inappropriate.
And I apologize, you're jumping around a little bit. So put aside sending transcripts back. I have concerns about that. Do you have any law for the proposition that prior consistent statements can only come in through the witness that makes the statement?
Well, I would point to a case. Let me pull it up again. I had it. Just give me a moment. One moment, please.
Yeah.
It's 366 P3rd 867, State of Utah in the interest of J.C.
I'm sorry, would you give me the site one more time?
366 P. 3rd, 867. And I direct the court to footnote 8.
Okay. All right, so I understand your objection there. Tell me why you think it's a Crawford problem. You had the opportunity to cross-examine Ms. Lauber. You did cross-examine Ms. Lauber. You used part of these interviews to cross-examine her, to challenge her on whether she just asked the law enforcement officers, investigators, just write her statement for her. I don't understand what a lack of confrontation Ms. Richins has had here.
Because Because what is happening here is now they are basically crafting testimony on her behalf. They should have asked her these questions. I haven't had an opportunity to cross-examine her on what they now want to bring in. They should have brought it in through direct, and instead, which I get was difficult with her. You know, she said she didn't remember anything. Instead of doing the hard work to try and ask her questions, they just want to put it all in. And they want to cherry pick what they wanted her to say, which clearly would have been very difficult to get her to say. So the easy way is here. We're just going to hand you the transcripts that show you what we wanted Carmen Lauber to tell you, but instead, here, just read it without putting in the whole story or giving me a chance to go back and cross-examine her. And I think requesting us to recall her is burden shifting. That is not what our job is. That's not what we needed to do. They needed to take care of their witness when their witness was on the stand.
And remind me, you objected to the addition of any part of the transcript at the time they offered it, correct?
For the same reason. They offered it after she was off the stand.
Had they offered it the 900 pages when she was on the stand, you would have said okay?
No, I would have said you need to cross-examine her, redirect her and rehabilitate her testimony.
And so how do you see the rule regarding prior consistent statements working?
They need to get it through her. They could have put on prior consistent statements through her.
I really don't understand. You're saying that prior consistent statements never come in. You only can ask questions. Please help me understand.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have never seen this done any other way than through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence. Let's hand them all the transcripts of
Well, no, be fair to how the rule works. Somebody testifies on cross-examination. Defendant makes a charge of recent fabrication, and then the proffering party has an opportunity to offer prior consistent statements to rebut the charge of recent fabrication. I hear you saying no, they cannot offer the prior statements. They can only ask more questions.
They can offer them through the witness. They can say, is this your statement? And what if she says, I don't remember that? Okay, then they can refresh. What if she says, I don't remember that? Well, then it doesn't come in.
Okay, I think that's where maybe you and I differ on the way the rule works. Do you have any citation for law that says, unless the witness remembers, these don't come in?
Well, off the top of my head, I'd have to spend some time, but I would look at Rule 613 of the Utah Rules of Evidence that talks about, this talks about prior inconsistent statements, but after the witness is given an opportunity to explain or deny the statement, an adverse party is given the opportunity to examine the witness about it. We don't know what she would have said. We don't know if she would have said, she may have very well said, no, I didn't feel influenced at all. That's fine. They could have asked her that question. Then I could have cross-examined her or recrossed her to say, well, what about this? What about this? What about this? Now I'm denied any opportunity to do that by just putting in statements. And I really don't know what else to say. I do think, as I look through the transcripts, they have only picked things that they want in that we don't know that Carmen Lauber would have agreed to. But had they wanted to put them in through her, at least then I could have questioned her I could have questioned her. I could have said, so this didn't make you feel pressured, so that didn't make you feel pressured. So they said this, so that made it, so you felt you were telling, I don't know. I mean, you see where I'm getting. And I don't have any opportunity to do that in this way. They can ask Detective O'Driscoll questions. We can cross-examine Detective O'Driscoll, and the jury can make a determination of that. But by cherry-picking statements that they wanted Carmen Lauber to testify to but didn't ask her, I think that's error.
It's not the cherry picking, it's the root, right?
It is.
I mean, you cherry picked statements too. Everybody cherry picks
right,
statements.
and they could have done it on redirect, and they chose not to.
So again, it's the root, not the cherry picking, right? If she were on the stand, the cherry picking would not be a problem.
They could have, because then I could have gone back and pulled out other statements.
I think we're agreeing. Okay. All right. All right. I take your argument seriously. Mr. Bloodworth, I'm going to have to take a look at this real quick. I understand this to be a threshold issue with respect to Detective O'Driscoll. Is that right?
Yes, Your Honor.
Okay. Anything further at this moment?
I think if he wants it, we just say send it over.
That's not what I meant there, right?
Your Honor, I'm pausing. Can we have 5 minutes?
Of course. Just so I'm clear, we'll take 5 minutes for you to confer with your team, and then you'll tell me whether this is a threshold issue that I need to decide before Detective O'Driscoll takes this.
Correct, Your Honor. It is now. That may change.
Okay, understood. We'll take a 5-minute recess. Thank you.
All right, so they're going to take 5. So the jury is there, but they're not in the courtroom. They were supposed to report at 11:30 our time, so 9:30 local time. So it's after 12. So it's been well, they were going to start at 11:30, so they would probably get there a little bit earlier. So they've been sitting around 40 minutes, at least 35 minutes, 37 minutes. Lots of things just happened. Most recently, okay, so this is entirely about Detective O'Driscoll, right? So Detective O'Driscoll is the lead detective. Took over for Jamie Woody. He's coming in. He's going to be their last witness on their case in chief. Then there's also talk about the state is holding evidence and the testimony, I should say. They're holding testimony for rebuttal. So this, from what I can tell, from what I can hear, O'Driscoll is going to be the last witness in their case in chief. Then they might have a rebuttal. So all of this, all that we've been going through for the last hour and a half, 10:30, 11:30, yeah, more than an hour and a half now, has been Detective O'Driscoll is going to be on the stand. He's bringing in transcripts of jail calls. He's bringing in transcripts of text messages of Kouri, text messages between Kouri and Ronnie, her brother, statements from Lisa, who is the mom, now Carmen, who we heard from before. And so it's all about Detective O'Driscoll's upcoming testimony and 900 pages. Oh no, that was Carmen. Carmen had 900 pages of her previous statements. So it's all about comments that Kouri made about Eric trying to take his own life. Her saying that she hardly knew Hayden Jeffs. She had so trying to impeach her on that, saying, "Oh, I hardly knew him," and yet she had a conversation with him, I guess, while in jail about using fent. So there's just lots of wrangling going on. What else? Eric joking to his friends that Kouri tried to poison him, but that's not what he did. I guess he did do that, but then he, let's see. So there was a lot of redactions that they wanted to have, and then there were a lot of redactions that they said, okay, we don't have to redact that after all, walk the dog letter. So that was really interesting. So O'Driscoll is definitely bringing in the walk the dog letter, and they want to make sure that the state says he doesn't care how it was recovered, but the defense is like, no, we definitely don't want that. We definitely do not want that her Kouri's cell was rousted, and we saw that. We did it in one of our deep dives. We had that pretrial hearing of how her cell was quote unquote rousted, and apparently this is part of a 65-page fictional manuscript, and this walk the dog was part of it. Let's see what else. So the state's basically going to show Detective O'Driscoll a copy and say, this is what was shown to Lisa / her mom. And then it was recovered by law enforcement in Kouri's personal items, right? And the judge is like, to the defense, if you object to foundation, then you're going to have a problem. So they're going to stipulate that. And defense, that's when defense, Ms. Nestor was like, we're not going to object to that because we don't want the jury to know that Kouri's cell was rousted. Then we go into like this vacation booking. They were talking about her, I guess, booking a vacation in St. George versus St. Martin. The other one was at St. Martin, but then I guess there was one in St. George. And then finally they ended with this statements about Carmen, and it's Miss Lewis who's having a big problem with this and calling it a Crawford problem, because they're saying, the defense is saying that the state should have brought all of this up when Carmen was on the stand versus telling the jury through another witness, hey, this is what Carmen said. And I agree with Miss Lewis. She's not going to have a chance to cross Carmen, but she can cross O'Driscoll. She can still cross him, and she'll say, well, is this what Carmen said? He'll be like, yeah, it's what she said. So she's saying she won't have an opportunity to cross Carmen in her statements. And the judge is like, well, you could recall her. I'm sorry, yeah, you could call her. You could call her on your case. But then Miss Lewis is like, well, that's shifting the burden. That's, what did she call it? Burden shifting? Whatever she called it, maybe burden shifting. I forget exactly what she called it, but something shifting. Basically saying, hey, that's not our deal. This is your witness. I want to have the chance to cross her. So, I mean, I can kind of understand that argument. Why the state didn't do it then, but then the judges, because she kept saying, this is cherry picking, and the judge is like, well, you cherry pick too. So everybody cherry picks. So let's see what else. And then the judge is saying, is this a threshold issue? Meaning, for the state, is this whole thing with Carmen a threshold issue? And I try to interpret that this has to happen, or else, right? That's how I interpret that this issue with Carmen is a threshold issue, and that they need to figure out if they want this to come in or not. It seems like it. I don't know. I could be wrong about that, but so. All right. Let's see. Jedzia Dax. Let's see. Amy asking about walk the dog. Well, it is pretty much Kouri telling mom to have Ronnie lie for her and commit perjury and say, this is what I want him to say. So it's pretty big. It's pretty big. It's Kouri wrote a letter, or wrote apparently a 65-page manuscript, and this was part of it. And the title is called Walk the Dog. And, well, let's see, we can bring it up. There it is. And she's basically telling her mom, Lisa, to have her brother, meaning Kouri's brother, Lisa's son, to lie for her when if he takes the stand. So it's pretty big. It's pretty big. Renee had to step away. Were they able to get the walk? It's 3 pages. Yes, that's a 6-page excerpt, if you will, of a 65-page manuscript, according to Kouri. And they got the first 3 pages in. Butterfly wings. Oh, watching from Australia. 3:15. Awesome. Is Aussie with us? Aussie, you have a fellow country person in chat. There you are. Aussie. Guess, oh, did I blow it? Guess where Aussie's from, Butterfly? You'll never guess where Aussie Gardner's from. All right, let's see here. Yeah, Hellrider, yes. Walk the dog, right? That's a good one. Sparkling Princess. I can only imagine how they will be if that other trial is live. The civil one. You're talking about the civil trial, yeah. Hey, if it's streamed, we'll check it out. Walk the Dog is a document that shows Kouri's very clear instructions. Yeah, I think so too. Butterfly wings. There you go. Good day, Aussies. And yes, yeah, don't forget, guys. We tell you this every day, but yeah, just be careful with the self-deletion. Just put an asterisk in there, or just misspell it, or you know the drill by now, guys. You know the drill. Amber, what's taking so long to get testimony today? There's lots of wrangling going on. There's a lot coming in. There's a lot coming in with O'Driscoll, and why they didn't sort this out before, I don't know, but they're sorting it out today while the jury is sitting around. Right, Hellrider? C. Gilmore, they came in, I'm going by our time, local time, they came in at 11:30 and it's 12:17. So they probably have been there at least an hour, because I would think you get there, I'd say 10, 15 minutes beforehand. So they've probably been there for probably an hour by now. Waiting in the back wings, having donuts, drinking coffee, tea, whatever it is. Amy, did the woman testify? Which woman are you talking about? Carmen, or at least who? I need, give me some more context there. See what else. Yeah, okay, so this is page 1. So this is basically Kouri saying, here, I took screenshots of the other pages too. Here's page 2. And we can read through this another time, because I think Judge is going to be coming back soon. And these are the 3 pages. Here's page 3. So there's page 3. So it's basically all about, we're so close to the end, let's push through, have a conversation with Ronnie before he meets with Sky. Sky Lazar is her lawyer, was her lawyer. Oh, there's the asterisk. Take vague notes on it all so you know before you walk the dog. Yeah, she's talking about, we will get those damn bitches. That's Eric's sisters. So clearly Kouri did not have a good relationship with Eric's sisters. So Grampy coming in hot. Awesome. With the 12 Trial TV Live gifted memberships. Welcome in. Thank you, Grampy. Appreciate that. We said welcome in. Welcome in, new members. And thank you, Grampy. Awesome. Welcome in, guys. Welcome in, new members, I should say. Super Ball thanks you. Hey, Mona, I would be shocked if Kouri testifies. That would be wildly problematic. Yeah. JMS, I have a feeling testimony will go into tomorrow. I think so too now that they're not going to start. Again, it's, let's see, it's 10:30 their time, so 10:30, 11:30, 12:30, so it's, say, 2 hours of testimony of direct. I think it's going to be probably I would say 3 hours. So they're going to come back from lunch, 1:30. They may only take a half-hour lunch, though. They may only take a half an hour lunch. So I would say 3 hours for 3 hours for direct. Cross always takes longer. They're probably going to cross him for at least 3 or 4 hours. Yeah, you're right. This will probably bleed into tomorrow. It would not surprise me that this will go until tomorrow. But that being said, this, from what we've heard, the state has said this is their last witness for their case in chief. We always have their rebuttal, but that will come after if the defense has a case. And wrongly, yes, at the bottom, take vague notes of all this so you remember before you walk the dog. Does that mean once taking notes, get rid of? That's what I'm thinking. Yeah, that's what I'm thinking. You can see it. This is page 3. See, take vague notes. That's the way I'm interpreting it. Basically, burn after reading, if you will. Because it also is on page 1. See but take vague notes so you remember with the asterisk, see the upper right. So that's the way I'm interpreting it wrongly. Is that it's burn after reading kind of thing. All right. Yes, burn after reading makes sense. That's what I'm interpreting that as. Walk the dog. Burn after reading. Oh yeah, he's got a lizard out there. Rafa's got a lizard. Oh, let's see. See, Mel, did Kouri claim that her walk the dog letter was somehow related to some book she was supposedly writing? Yeah, 65-page manuscript. It was like in the middle. That's what the state just said. It was like in the middle of a 65-page manuscript. Oh, rock and roll. Yes, you are back. Just had to drop info at your accountant. Welcome back. Welcome back. Sherry, good to see you. She thinks she's the smartest woman on the planet and can fool them all, in your opinion. See, yes, this will be very interesting. So Detective O'Driscoll is going to bring in all kinds of stuff. He's going to bring in, the highlight to me is going to be this walk to the dog letter. Carmen, he's going to bring in his conversation with Carmen, jail calls, conversations between Kouri and her mom, Kouri and Rob, Ronnie, I should say, her brother. This is going to be, this will be, this is going to be their last witness, apparently, unless they have a rebuttal. So this will definitely be a very, very interesting case. Superball's doing fine. She's relaxing over here. Superball's relaxing over there. So yeah, she's doing okay. Trying to stir up. Here she comes. Well, hi. Well, hi. Yeah, it's a good girl. All right. As she steps on my computer board, keyboard. Hi, Superball. Good girl. So yes, Superball's doing fine. Yes, Grampy. Everybody loves you, Superball, as she gets fur up my nose. All right, kiddo. That's a good girl. Yep. And she's going to sit right here. Hi. Yes, a good girl. Everybody loves you. Oh, Roger, you going to come up? Ugh, so congested. All right, and they're back.
Mr. Bloodworth, before you weigh in, I need to fix a misstatement that I made while discussing Detective O'Driscoll's potential testimony. I made a comment in passing that he cannot relate Ms. Lauber's statements because it would be hearsay. That is overly broad. To the extent that the statement by Ms. Lauber that Jeff O'Driscoll would seek to relate while testifying qualifies as a prior inconsistent statement under 801D1A or a prior consistent statement under 801D1B, it is categorically not hearsay and he can relate it. By the same token, it can come in through him. Ms. Lewis, I took a hard look at the case you cited me to, 366 P. 3rd 867, footnote 8. There, the Utah Supreme Court related the competing positions by the state and the respondent. Those competing positions are substantively identical to the competing positions of the state and defendant here regarding how statements under 801D1 are to come in, and the Utah Supreme Court expressly declined to reach the issue. They did not rule that they must come in through the declarant. So, as I sit here today, there is no authority for the proposition that prior inconsistent or prior consistent statements can only come in through the declarant witness as long as the declarant witness testified and was subject to cross-examination. Indeed, it is defendant's cross-examination of Ms. Lauber that creates the foundation for admission of prior inconsistent statements based upon Ms. Lauber having not remembered or having forgotten, though that's not what the state is seeking to do here, and prior consistent statements based upon an express or implied charge that Ms. Lauber was acting from a recent improper influence or motive, to wit, pressure applied by, among others, Detective O'Driscoll, the U.S. Attorney's Office, agencies like that. There is not a Crawford problem here. I also have another thought regarding the transcripts going back, if you want to discuss that.
So maybe we can get the court's thought, and then I can incorporate that into the state's position.
Sure. Under Wyatt v. State, 2021 UT 32, under paragraph 21, the Utah Supreme Court abrogated the common law rule that prevented testimonial transcripts from going back into the jury room based upon a concern of undue influence on the basis that Rule 17K of their Utah Rules of Criminal Procedure does not allow for any categorical exceptions to exhibits going back with the jury because the jury may take with them, quote, all exhibits, end quote, except those, quote, that should not, in the opinion of the court, be in the possession of the jury, end quote. Now, typically that's guns, knives, poison, explosives. I still have some concern that given the volume of testimony that the jury hears, the only transcripts they would have in the jury room being this 100-ish pages of Carmen Lauber would attract some unwanted attention on appellate review, but under Wyatt v. State, 2021 UT 32, there's no categorical exclusion of them. Take it from there, Mr. Bloodworth.
So, Your Honor, it's the state's position. I know I'm recapping a little bit of what you just said. It's the state's position that the court can admit the transcripts through Detective O'Driscoll. We don't need the declarant, Carmen Lauber. It's the state's position that there is no Crawford issue, in part because of the 801D1 requirement for opportunity to cross has been satisfied in this instance. It's the state's position that the defense, to the extent they want to recall Carmen Lauber, is not burden shifting. It's just a defense strategic choice. And it's the state's position that the transcripts can go back to the jury. Now, having said all of that, prophylactically and out of an abundance of caution, the state is trying to, through her attorney, recall Carmen Lauber, put the transcripts in through her, and then publish 100 pages of transcript. As much as the state thinks that is horribly, horribly inefficient and unnecessary. We've reached out to her attorney. I do not yet have an answer.
Okay.
This is a threshold issue for, I don't know, the midpoint of Jeff O'Driscoll's examination. So I propose our next witness is Chris Cochagimos to clean up some stuff from yesterday. I propose we next call him. We then begin the state's direct examination of Detective O'Driscoll. That'll probably take us till lunch. I may have a better answer at lunch as to how the state will proceed.
Okay. Let me just ask some mechanics questions. Why can't the state just ask Jeff O'Driscoll a bunch of questions about whether certain exchanges with Ms. Lauber occurred? And, to the extent he doesn't remember or can't remember specifically, use the transcripts to refresh his recollection and even show the jury, publish them at that time, but use him as the root. And if you want to call Ms. Lauber, you're entitled to do so.
Your Honor, that may be the root anyway, and it may just, from an efficiency standpoint, going through the questioning to ultimately get to refreshing and publishing, it seems to me that that's a waste of time. It will be more efficient to just publish the 100 pages.
Okay.
Because that's where we're going to land anyway.
All right. Ms. Lewis, please proceed.
I just want to make a record.
Go ahead.
We stand by our objection that allowing prior consistent statements to come in without a sponsoring witness is a violation of both the Sixth Amendment right, of our client's Sixth Amendment right, and Crawford versus Washington. It also violates her right to due process. Under the Utah State Constitution and the federal Constitution, she is not receiving a fair trial. And the remedy that we should recall the state star witness absolutely is burden shifting, and we stand by our objection. If those 100 pages are going to be published, we want all of it published. We want all 1,000 pages.
All right. And how do you want that to occur? Do you want to just play the interviews with Ms. Lauber?
Sure, we could do that. We could just play them all. They're 7.5 hours, but that's how we want to do it.
And tell me why you want to do that.
Because there are numerous other portions of the interviews where she is being influenced by law enforcement and shows that she's willing to just go along with whatever they say, just as she stated. But I think to pick out, particularly, like I said, the May 10th interview, there are a lot of things she says in that interview that are inconsistent with all of her other statements, but the state just wants to publish that she was going to testify before the grand jury, which I don't even understand that. I mean, all that does is cause the jury to speculate and confuse issues. And that's just one example out of what they've pulled out of the transcripts.
We're back where we started, Mr. Bloodworth. This is the position the state originally took. Does this change anything?
Your Honor, it's largely the state's initial position. The initial position of the state was then not to publish them, right? It was just to send them back so that the jury could, if they wanted to. I'm happy to send the whole things back.
Ms. Lewis, speak to that.
We're not asking, that's only if, we are not suggesting that that should happen, only if we're overruled. We'd rather it all go back.
Specific part, you got to be a little bit specific.
We're not suggesting, it's not our position that any of this should go back. We're only saying if the court's going to allow some of it to go back, then under Rule 106, we need it all to go back.
Forgive me, you've pivoted again. It's stay away from going back. Let's just stay on publishing. So, I understand defendant's position to be if any of it's published, all of it has to be published.
Correct.
Okay. In response to that, the state, as I understand it, is suggesting I'm inferring, in the interest of efficiency, rather than publishing all of it, just make all of it available to the jury through the recordings, and then allow counsel to make whatever arguments they want to make about, you should go back and listen to this part, because you'll see this is what was happening. Speak to that for a minute. You could do that by stipulation.
I'm not going to stipulate to that. No.
So
Our
you're
objection
saying publish.
stands.
Let me start again. Imagine that your objection to publishing anything is overruled, and that's the world you're living in. How do you want to proceed from there?
I mean, I think I said that. Then it should all go back. Or
Again, you keep skipping to going back. I want you to talk about publishing for a minute.
It's showing up on the screen.
see, my hesitation is just efficiency. Like I said, it's over 7 hours worth of video. But if that's how the court wants to do it, then yes.
No. That's what I'm asking you. So imagine, here, I'll just make a ruling. I have considered carefully the authorities cited by defendant and the state. I've looked at the text of Rule 801. I'm ruling as a matter of law that, one, there's no Crawford problem here because Ms. Lauber testified in open court under oath, was cross-examined in open court under oath. It is the cross-examination of her regarding the conduct and circumstances in her prior interviews with law enforcement and other agencies that creates the circumstances providing the foundation for admission of her prior consistent statements under 801D1B. So, the defendants further, the court is not persuaded that the only witness through whom a prior consistent statement may be admitted is the declarant witness that made the statement. The court has not seen any authority for that proposition. So, to the extent the defendant objects to any of Ms. Lauber's prior consistent statements coming in any way, that objection is overruled. So, Ms. Lewis, take it from there. Some of her prior consistent statements, as designated by the state, are admissible under Rule 801D1B. It's how we're going to provide that information to the jury that I need some input on.
Well,
we could just publish. We could admit and send back into the jury room. Speak to those two options.
Well, my understanding was that under the case you just cited, Wyatt, that you were going to allow the portions to go back to the jury room. Did I misunderstand that?
Well, I think there's a basis to do so. It gives me the willies, quite frankly, and that's why Mr. Bloodworth, out of an abundance of caution, is saying prophylactically to prevent any appellate issue there, we would just publish. But if the defendant believes, Judge, if you do this, the least prejudicial way for us to do it is to send the recordings, all 7.5 hours, into the jury room and allow counsel to make arguments about what they show and what the jury should take from them, you could do that by stipulation.
No, I don't want to do that. I think that even though it's not efficient, the appropriate way is if any of the interviews are going to be published, they all need to be published.
Okay, only published.
Correct.
All right. I appreciate your position. Mr. Bloodworth, take it from there.
Your Honor, the state moves to just publish the narrowly tailored versions that we proposed as whatever it is, 8-57 through 63R. I think beyond so, I don't think there's a 106 concern beyond that.
I don't know. We're going to find out, but okay.
Yeah, and as a compromise, the state is fine with sending full videos back, or some mix of publish the narrow pages and send a full video back. But the notion of publishing nearly 10 hours of interview I don't think it's productive. I think it's a waste of the jury's time.
Okay. Ms. Liz.
We object to it all going back. It's the same problem. The problem is the same as, well, let me rephrase that. The jury's been told they're to rely on their memory of witnesses. If the whole thing goes back, they can go over and over and over her statements on the video, which is not what they can do with any other witness. So if it comes in, it needs to be published, and then they have to rely on their memory just like they would with any other testimony.
I appreciate that position. Why are we publishing all of it rather than just the parts or some parts of what the state has designated?
Because there are... I mean, I already made my issue, or raised the issue about the May 10th
We'll get
transcript.
there specifically. Any others?
Yes. I would have to go through, I have gone through, but to go through right now every specific part. But there's a lot that's being left out, and a lot what's being left out are the statements where officers are telling her about what she needs to do in order to not have to go to jail, what kind of deals they're willing to make for her, what she needs to do and say, and that's not included. And yes, some of it she was cross-examined on, but there's a lot more statements like that she was never cross-examined on.
Well, that's choices defendant made, though. So here, in order for me to include additional material, there has to be some basis. Is it a Rule 106 request?
Yes, but in all fairness, the choice was made because that was all that she was questioned on in direct examination. Had there been a redirect back to where I started, then I would have chosen other portions, but I have lost the opportunity to do that.
You haven't, but that's okay. You can certainly have access to this witness.
Well, I think we've made our record on that.
Are there Rule 106 portions you want to add, having reviewed the designations?
I think we need all of it. I think the jury needs to see exactly what her demeanor is, how she acts with the officers, how the officers treat her. There are numerous other parts of this transcript that may come in through Detective O'Driscoll. I don't know yet. I mean, I don't know the answer to that fully yet. But there are a lot of other statements by both Detectives O'Driscoll and Detective Maynard that go to show that she was unduly influenced. There's a lot of it.
I know, but you're not giving me which ones they are.
It's because, I mean, all of them.
Okay. All right. It's hard to rule on because it can't be all.
Why not?
Well, certainly your position isn't that every single statement made by the law enforcement officers and every single answer is evidence of undue influence.
It shows an arc.
That's the state's point.
Right. I know, and now if we're going to do part of it, then we need to show the whole arc.
That's not how Rule 106 works. I need you to be more specific.
I don't have specific outlines right now in the 1,000 pages of transcripts as to what we would want and what we would. I mean, we want all of it. If you want me to go through all 1,000 pages again and try and figure that out, I mean, guess we can find some time to do that. But
Okay. So, Mr. Bloodworth, as for today, how does the state propose to proceed?
So I propose we call Chris Cotodemos. I then will call Jeff O'Driscoll. We will get to maybe, 45 minutes into his argument before this will become an issue.
Okay.
My sense on timing, Your Honor, is this doesn't become an issue till a lunch break.
I'm not sure what's going to change between now and then, though, in terms of the issue of whether to play everything or just the parts that the state has designated under Rule 801D1B.
Fair.
So, all right. The issue before the court is the state's motion to admit redacted exhibits 8-57R through 8-63R. The state is offering what it views as narrowly tailored portions of the transcripts of Ms. Lauber's prior interviews with law enforcement investigators and other government agencies as evidence of prior consistent statements by Ms. Lauber under 801D1B to rebut an express or implied charge that when she testified in open court in this case, she acted from a recent improper influence or motive in so testifying. In response, defendant does not provide a sufficiently specific argument that the state has over-designated any of these portions beyond what would be permissible under 801D1B. And though defendant makes a Rule 106 argument regarding additional portions that would be necessary to provide context for, explain, or qualify Ms. Lauber's statements, their position is that all of it does, and that does not provide the court with a sufficient basis to rule one way or another whether other additional portions of these prior interviews are required to be included under Rule 106. Based on the record currently before the court and the procedural posture that brings us to this point, the state's motion to admit redact exhibits 8-57R through 8-63R is granted to the following extent. The state may publish these exhibits and use them with witnesses that are on the stand. Sitting here today, the court is not prepared to rule and does not rule that 8-57R through 8-63R may go into the jury room as admitted exhibits under Rule 17K because, sitting here at the moment, the court determines that they should not, in the opinion of the court, be in the possession of the jury to make absolutely sure that the jury does not give undue influence to these specific portions of a single witness's testimony as compared to the testimony of all the other witnesses in this case. Mr. Bloodworth, anything further on that?
No, Your Honor.
Ms. Lewis.
Yes, Your Honor. We actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
2 days.
Yes.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time of the jury when this motion was filed 2 days ago and I raised it with you yesterday morning.
Okay.
Your request for a 2-day continuance is denied.
Ask for a 1 day. Ask for 1 day.
All right, a 1-day continuance then.
To tomorrow morning.
Yes.
And what is it you're going to do between now and then?
I guess we're going to go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yeah.
Mr. Bloodworth.
Your Honor, the state objects. Not only did the state file the motion 2 days ago with the specific portions, this whole issue was teed up last week when Carmen Lauber testified. I don't think there were any surprises in the motion, and I think the state's motion and the redacted versions it filed were probably what everybody expected.
All right. And Ms. Lewis, you'd be filing something in writing that had additional either Rule 106 inclusions or some identification of where the state has over-designated things, correct?
Yes.
And your position would be that additional parts of the transcript should be shown to the jury, is that right?
Yes.
That is so slow. There's just no way this is going to work. There's no way we can edit the video?
I'm not tracking, Your Honor.
Each of these transcripts corresponds to a video of an interview, correct?
Correct.
It would seem that watching and listening to the video is more efficient than reading the transcript.
Oh, 100%, Your Honor. Based on the ruling right now, like 2 minutes ago, we have launched our video editor to create the video now of the narrowly tailored portions. That's how we would publish them. Is by playing the video.
Okay. All right.
One suggestion could be if the state wants to hold off on publishing all of this and see where they get with their testimony of Detective O'Driscoll, and maybe through appropriate direct examination they can get in the portions they feel are important, and then maybe none of this would be necessary if that decision could be held off. And then if at the end of the day they still want to publish the whole thing, then we would ask that we not hold court tomorrow so we can do that. I think that would be more efficient.
Maybe.
Your Honor, we're going to want to publish it. Let's just cut to that chase.
All right. Folks, give me 5 minutes. Actually, just give me till 11. Okay. We're in recess.
All right. What a big freaking mess. This trial, I should say. This trial is just a disaster. Okay, so high level, the state wants to bring in certain redacted portions of Carmen's statements through O'Driscoll, who is the lead detective, and the defense is basically saying, well, if they're going to bring in parts of it, we want to bring in everything. The problem with that is like 7, 8, 9 hours, 1,000 pages. Who knows? It's everybody's shifting everything. Some people are saying it was 900 pages, 1,000 pages, 7.5 hours, 9 hours. So the defense is basically saying, well, if you're going to allow part of it, we want the whole thing in. We don't want them to cherry pick because we won't have a chance to cross. I don't understand that thinking, because if you're going to bring in the entire thing, you still don't have a chance to cross. But anyway, that's what the defense wants. And the defense is basically saying they want a continuance. They're not basically saying, they are saying they want a continuance for 2 days. And judge is like, no way, that's denied. And then Miss Nestor is saying, well, ask for 1 day. So then Miss Lewis says, how about 1 day? The judge is saying, well, then until tomorrow. And she's like, well, I guess if we're going to have to go through the entire transcript. I mean, just the attitude is really off-putting. But anyway, we won't talk about that here. So, of course, the state objects to it because he filed this 2 days ago. He said this was teed up when Carmen testified last week. And then now the defense is saying, well, if the state... So this part of O'Driscoll's testimony would come in around 45 minutes. So they have another witness. So now we found out that there's yet another witness. So that's Chris somebody or other is going to testify. So they're going to have this guy testify. Then they're going to bring up O'Driscoll. His testimony is going to be about 45 minutes into his testimony before this whole thing with Carmen comes in. And then that's where everything blows up. So now the defense is saying, well, let's see where the testimony leads, and maybe none of this is necessary. And the state's like, yeah, no, we're going to want to publish this whole thing. Let's just cut to the chase. We're going to want to publish this whole thing. So that's where we are. Judge is taking a break. The jury's been there since 11:30 our time, and it's almost 1 o'clock. So they've been there for an hour and a half. So, judge does not want a continuance. That's the last thing this judge wants, is to have a continuance. No way. And I agree. No way. Do not allow a continuance. But the state's saying, out of an abundance of precaution for appeals, he's trying to be, proactive and prophylactic, as he keeps saying, and he wants to put a rubber over this and not have the appeals kick in and say, oh, well, we didn't give you this chance, And the defense is they're digging their heels into the ground, into the sand. They're like, nope, you bring in part of this, we want the whole thing in. And then they're complaining that they have to review it. So they want the whole thing in, but then they're complaining that they're going to have to review it again. So, what do you guys think? Heidi, you think it's pretty ineffective? Widespread panic. Hey, good to see you. Let's see. Have the defense attorneys not heard of legal assistance? Well, I think she kind of addressed that. She's like, we don't have. I think she kind of addressed that. But yes, they watched the video, give an outline of what happens when the attorneys look at what they might be significant, not rocket science. I think she actually said we don't have. I think she actually did say that. That's really funny that you brought that up, because I think she actually did say that. Let's see. Sherry, why didn't they already review it then? They did. I think she said they did review it, but probably a long time ago and they don't remember. Let's see. This is just appeal. Yeah, this is all for appeals for sure. They want to make sure the state wants to make sure, and the judge wants to make sure that this does not come up in appeal. So they have their own law firm. Yeah, right. Did they say that it's not like they have? I'm pretty sure she said something to that effect. She said that's not like we have clerks, or we don't have our own review team. She said something like that. Hold on a sec. Hold on. She did say something to that effect. It's not like we have our own. What did she say? Let me see if I can find that.
Let's just cut to that chase.
Is that right?
Yes.
Is
All of this, Detective O'Driscoll, and maybe through appropriate direct examination. But
Let me see if I can find that.
And the state has or.
Was it here?
All right.
it fine? And I think
Read it.
Not included under Rule 106.
Your request for a 2-day continuance is
we're gonna go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yep.
All right, I'm not going to waste time. I'm not going to waste time. We've already wasted enough time. Anyway, Jane, she said she doesn't have a team in the background in another room. Yeah, something like that, something to that effect. So, but they have their own law firm, so they must have somebody. They must have somebody to help out. But the problem is that it has to be done like right now. The problem is they want it done right now. I think that's the issue. So even if they had a team of 10, they still need time to do it. You know, they need to do it in the next, well, I guess I'd say the next 2 hours, and that's going to be pretty tough to do as well. Let's see, Grampy. Someone is asking if Ms. Richins is paying. No, these are public. These are public defenders, even though they have their own law firm. That's what's interesting about it. So she's not paying for them, but they are public. But they have their own law firm. Let's see. All right, she's a prominent criminal defense lawyer. She has 30 years of experience. She's 21 years as assistant federal public defender. This is Miss Lewis, Nestor Lewis. I think right now, yeah, so she has her own, yes, so both her, yes, so it's Nestor Lewis. So they are together. So it's Nestor and Lewis, and they are public. Oh, wait, here, he's coming back.
Let's go back on the record. We're back on the record in 231-500-139. Counsel for the state and for defendant are present. Defendant is present. Ms. Lewis, the defendant, asked for a one-day continuance to allow time for defendant to, on the one hand, review the designations made by the state, determine whether there are some over designations that go beyond what should be published under 801D1B, and also to offer additional designations that in the defendant's view should be included under Rule 106. That request is granted. We need to come up with a set of deadlines by which defendant will take those positions in writing, by which the court and the state can review them, by which we can have a discussion on the record about which of defendant's positions are persuasive, and if possible, Mr. Bloodworth, and I know I don't have any control over this, I'd really like to build in time for the state's video editor to take whatever I decide and turn it into a video, so that when we're publishing a video, not just pages of a transcript. Let's work backwards from there. Mm-hmm. How long is that process? And if you need to take a moment and step out and tell your video editor to press pause, I'd understand.
So, the state will, within an hour or two, maybe within 3 hours, have the video that corresponds to the status quo of the 6 exhibits.
Understood.
Now, depending on how much additional comes in and how much additional goes out.
Right.
Hard to say. 4 hours?
Okay. All right. As a practical matter, do you think we should start midday tomorrow or just come back on Thursday? I was hoping to come back midday tomorrow.
So we can do that, assuming. Was the court considering a deadline from defense something like 6 p.m. today?
Yes, something like that.
If we get that at 6 p.m., my sense is by 8:30 tomorrow, the state will have a response. The court rules by
9:30.
9:30. We can probably get the video done.
Okay. Ms. Lewis.
We're just discussing. I don't think we can get it done by 6.
I don't understand why. I mean, the transcript is only this much stuff printed in 12-point font.
But
the Rule 106 designations would be immediately before or immediately after. And to the extent you're going to de-designating, you're just taking stuff out of those. So it's a relatively focused inquiry. You can go back and watch Carmen Lauber's entire direct and cross on court TV at 1.5 speed to refresh your recollection of what she said on the stand in order to determine whether this is consistent or not. To the extent you want to get more beyond this, I'm not sure you're entitled to do that.
I don't understand.
Well, if, for example, there's 200 pages of interview with Jeff O'Driscoll the first time, and the state's just trying to put in 20 from the beginning, you don't get to skip to the end and say, well, these last 40 would be really helpful to us. We made a strategic choice not to ask Carmen Lauber about them when she was on the stand, but we'd like to put them in now. That's not this exercise.
I'm not sure I understand what you mean. The portions of the transcript that they pulled out are from portions of all 7 interviews.
I agree, but they're not. They're just portions that are prior consistent statements. And so it's, did they over-designate? This goes beyond a prior consistent statement. Or is there some stuff immediately before or immediately after under Rule 106 that's required to qualify, provide context, or explain?
Your Honor, can I add a small wrinkle to that?
Sure.
In addition to prior consistent statement, it is rebuttal on recent motive to fabricate.
Yeah, that is the same. That's that's the prior consistent statement rule.
I think there were 2 separate things in 802D1, but maybe we're saying the same thing.
801D1B.
I mean 801D1, yeah.
Is consistent with the declarant's testimony and is offered to rebut. So
Right.
It's the same rule.
Okay, got it.
I don't see you doing prior inconsistent statements based upon a lack of memory.
Nothing in A.
Right. I think we see it the same way.
Okay.
We have till 11 p.m.
No. I need time to read it. The state needs time to read it. This is possible. I want to make sure that we have a common understanding of what you'd be permitted to do under 801D1B and Rule 106. This is not an opportunity to recross Carmen Lauber. If you want to recall her, I'm not making any statement about that. But to the extent there was stuff you wanted to put in your cross that you didn't, you're stuck with that for now until you recross her. If, on the other hand, there is an over-designation by the state under the bounds of 801D1B, I need to know. And if, in defendant's view, There's a Rule 106 inclusion that's required before or after these designations. I need to know.
Understood.
Okay. So 6 p.m., we need it in writing, filed in the case, please. If you would separate out what you believe need to be de-designated versus what you need to be, what I think needs to be added under Rule 106, I'd appreciate that. We'll reconvene at 8:30 tomorrow morning. Yes, Mr. Bloodworth?
Yes, sir.
Okay. Now, in terms of how to proceed for the remainder of today, do you want to put Kouri on and get him done, or do you want to break now?
Your Honor, if we can call him, he's 10 minutes.
Okay. Any objection, Ms. Lewis?
Eating into our time.
All right.
Oh, okay.
Well, he's only going to be 10 minutes.
Yeah.
All right.
We'll take an hour.
Okay. Got it. And then we'll invite the jury to come back at 1 p.m. tomorrow. Does that sound reasonable?
Yes, sir.
Okay. Very good. Anything else before we invite the jury in, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay.
So the jury's been there for about 2 hours. Jury's been there for about 2 hours. They're going to have a witness that's going to last 10 minutes, and then they're going to be sent home. I know I would be very upset at that if I was a juror, but that's the way the court goes sometimes. So they're going to have this witness come up, 10, 15 minutes. They're going to send people home, and then they're going to break for the day.
We still have Taylor and you. Okay. Yeah. What's that? Allege. Have a seat as you come in. Thank you. Have a seat. Thank you. Ladies and gentlemen of the jury, I greatly appreciate your patience while we worked through some legal issues. We will proceed with a witness from the state, and then I have some scheduling notes for you. Mr. Bloodworth. Oh, Ms. Sherbanek, my apologies.
No problem, Your Honor. Chris Kouri, please.
If you'd step in front of Brady.
Will you please raise your right hand? Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Right.
Thank you. Have a seat. Good morning.
Good morning.
Although the jury knows who you are, I'm going to have you state your name and spell your last name for the record, please.
It's Chris Kouri, Kotrodimos.
Now, we brought you back to talk about a couple specific issues. We know from your prior testimony that when you reviewed data from Eric Richins' phone, specifically for February 14th, 2022,
Yes.
you looked at the Verizon call records.
Correct.
Those included text messages.
They did.
And that's the raw data that we talked about throughout your testimony.
Yes.
Is that right? And tell the jury, for an outgoing message from Eric Richins, how would Verizon list that time zone in their record, in their call record, that raw data?
Well, it would depend on what type of message it was. For an SMS text, which is just a normal type text, it would route it through their normal server. It would be in local time. For MMS, that message has to be routed through a server, and so they use the server to route that call, and it would have a timestamp for the location of the server, not necessarily the device.
So when you looked at those records, the outgoing messages for Eric Richins' phone in the Verizon records, what time was reported for an MMS outgoing from Eric Richins' phone?
So there was an outgoing, in the record, there was an outgoing MMS at 12:23 p.m.
Would that be 12:23 p.m. in Utah?
No.
So what would the time of that outgoing message be for us in Utah?
So we're 2 hours behind, so it would be 10:23 a.m.
Scott, if we could put up 3-14D, please. This was previously admitted in Mr. Kotridemus' testimony. We can publish it to the jury.
Okay, there you go.
So we entered this exhibit through your testimony last time, and we talked about this gap in activity from Eric Richins' phone. And so what you've just described conforms with the raw data. Is that right?
Yes.
And describe it again now that the jury can see the time frame we're talking about. If a call record or a text message MMS showed outgoing from Eric Richins' phone at 12:23 in the raw data, you confirmed that that would have been 10:23 in Utah.
Correct.
How did you verify that?
So, one, just the knowledge and experience of knowing that that's how Verizon routes MMS messages. They use an Eastern time zone, which is consistent with their headquarters location. So to verify that, for time zones are very critical for analysts, obviously. So what you would do is, if you have a source to look at the original text, and in this case we do, which would be Eric Richins' his phone extraction, his cell download, I would expect to see, based on the time difference, an outgoing MMS text at 10:23 a.m. versus 12:23 p.m. And I did find that there was an outgoing message at 10:23 a.m., an MMS message to that number, and it was a photo.
So essentially, through your analysis and changing the time zones as necessary, this exhibit is still accurate.
Yes.
Okay. Scott, if you could put up 3-39D, page 5, please, for the witness. This has previously been admitted. And you can publish it as well. And you can blow up one of those messages. So now that we're talking about time zones, describe for the jury how we get to the times that are listed in all of these text bubbles, and so that the jury knows all of the messages that we have entered have these timestamps on them.
They do, yes.
And how do we get to the time that is on there?
Okay, time zone issue again. Okay, so phone extractions from software are provided, those readable files are provided in UTC 0. So to determine local time of when that activity on that device happened at the local time, you have to adjust. So Utah is -7 UTC during normal standard time. It is -6 UTC in daylight savings. So we just switched on Sunday. So now everything until November, when we switch back again, will be -6. So the -7 and the -6 denoted in these messages is a adjustment that is made by the software to denote local time versus software time.
So for each of the messages that the state submitted in this case, they have been adjusted to local time?
Yes.
Okay. Those are all my questions.
Sure, thanks.
Mr. Rollins.
No questions.
Okay. Sir, you can step down. Thank you.
Thank you, sir.
Council will proceed with the scheduling notes, correct?
Yes, Your Honor.
Ms. Lewis?
Yes.
All right. Ladies and gentlemen, I appreciate your patience this morning. We've been working very hard on some legal issues that will materially increase the efficiency of the presentation of evidence going forward. I know it's hard for you to know that, not being in the courtroom. I'm just asking you to take my word for it. We have more work in that regard to do. Rather than have you sit here while we do it, we're going to send you home for the day and not ask you to return until 1 p.m. tomorrow. So we will recess until 1 p.m. tomorrow. As always, during this period of recess, please do not speak about the case with anyone. Do not allow anyone to speak about it with you. Please do not watch, listen, or read anything about the case. Please do not do any research of any kind. I greatly appreciate your patience. Travel safely. 1 p.m. tomorrow. Please rise for the jury. All right, folks, have a seat. Mr. Bloodworth, anything else on the record today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Ms. Nestor?
No, sir.
Mr. Ramos?
Thank you, Judge. No.
Okay. 8:30 tomorrow morning. Please travel safe. We'll be in recess. Thank you.
All right. That, I guess, is it for today. We're not quite sure what we're going to do after this, as I'm sure a lot of people are, but let's see. All right. Let me think here for a second. All right, so he's letting the jury go until 1 o'clock local time, which would be 3 o'clock Eastern. That's tomorrow, but the other parties are supposed to be there at 8:30, which would be 10:30 Eastern. So it looks like tomorrow we'll start streaming at 10:30. Hold on a sec. I need to talk to Aaron. So let's just hang tight. Let me just put some music on for you guys. You know what? We'll get Kitty Cam going and we'll see what we're going to decide after this. So we'll get Kitty Cam going and we'll decide what we're going to do.
items left over in the
All right. Welcome back, everybody. We are going to have something for you guys to watch with us, since tomorrow is going to be all about... hold on a sec. Okay. So tomorrow is all about the walk the dog letter, right? So we thought we'd start there. We thought we would start there. Uh-oh, what happened to my... All right, so tomorrow is all about walk the dog letter. Well, it's not all about it, but a lot of it has to do with Carmen, but walk the dog is one of the big parts. So what we're going to do is we're going to show the... hold on. So Selena K is, let's see. So Selena says she asked Mr. Ramos when he was on his way into the courtroom. He drinks espresso in the morning in a black Yeti cup, and then tea he drinks in the afternoon is peppermint tea. So there you go. It's the tea. Okay, nice. Thank you, Selena. So Selena asked Mr. Ramos what he drinks, and it's espresso in the morning and then peppermint tea in the afternoon. So cool. Thank you for that. Awesome. All right. So we're going to take a step back because live court is done for the day. So we're going to look into this walk the dog letter a little bit more. So we're going to show these correction officers talking about how they obtained the walk the dog letter, and then we're going to show we're going to show Sky Lazaro arguing why the walk the dog letter should not come in. So that's what we're going to do for the next couple hours. Hopefully you guys will stick around and enjoy. And let's do this. So let's check this out.
Could you tell me what initially led to the search at that time?
Do you have a specific search?
Yes, let's start with, I believe there was a search of Ms. Richins' cell on September 13th of 2023.
Okay. So Ms. Richins had a medical episode, and so there was a brief search initially after medical had treated her. And that was a quick search to look for any obvious contraband left over from EMS personnel. And then shortly after that, there was indication that there was possibly something held up on a video chat.
Okay, I'm going to ask you about that, but let me just take it one step at a time. So initially, she was taken out of the jail for a medical situation.
Yep.
And there was a search on September 13th, and all you were looking for was if anything was left behind by the EMTs, is that correct?
Initially, yes.
Okay. And then when was it you became aware of a video call that led you to want to search the cell further?
So it was while she was away from the jail that was brought to my attention that there was possibly something held up in a video chat. So we searched the cell looking for a piece of paper with cursive handwriting on it.
And that search took place on September 14th, is that correct?
13th, I believe, is my dates.
So, all right, so the first search on September 13th, you didn't seize anything from her cell at that time, is that correct?
No.
And you believe the second search was September 13th?
So there was an initial search of just immediately nothing to do with any case. It was just a contraband search of any medical items left over in the immediate area. And then while she was away, there was a
indication that there was possible issues with a video conversation where she held up a piece of paper.
And on that occasion, did you search just her cell, or did you search the entire pod?
It was just her cell on that one.
All right, and that was also September 13th?
Yes.
And nothing was collected on that search either, correct?
Nope.
So what led to the search on September 14th of the pod and Ms. Richins' cell?
So there was random cell searches of two different sections, Golf Pod and Bravo Pod, and then also with her medical condition, she was going to be moved to a different cell for observation.
All right. Alex, can you just put on, I'm going to show you some videos of the search on September 14th. We'll try not to go through every single one of them. Could you start pulling up? It's State's Exhibit 69, but it's number 8 on our list. And before we start that, well, actually, no, go ahead. Let's put that on, Alex. Thank you.
Your Honor, can I just offer the court some context? The video system, because it's so data heavy.
Ask him about it. But
Oh, okay.
I'll ask him.
That's fine.
That's fine. Okay, yeah, just don't pause it for now. Let me just. So before we start, can you tell me, is that you in the video there?
Yes.
And which of those cells belongs to Ms. Richins?
I believe at this time Ms. Richins was in 4, which is upstairs.
In fact, it's the top right cell, is that correct?
Correct, yep.
That one that is being pointed to on the screen? All right. And the video camera where's that video camera?
It's elevated, it's on the back wall.
Is that the only camera in that pod?
It is, yes.
And
next to an observation cell that's in cell 5.
Where's that at? Can you?
It is the bottom left corner.
That we can see? Or left corner over there?
Yeah, so that will be just directly in the cell. It won't view anything else.
All right. So who runs the video camera?
What do you mean?
Is there someone in charge?
It's it's like an ongoing thing. Observation cells can be turned on and off.
Is the video camera run all the time or just?
The main section cell, yes.
All right. And that video camera, as we're going to see in these videos, it freezes a lot. Is that correct?
I believe it is a motion-based.
You believe it's emotion-based?
Yes.
So if it's not...
If there's no movement, I don't believe it records until it senses movement.
All right. We'll talk about that as we look where some of it is where nothing is moving. Who is it that collects the videos from that camera?
I believe it is our administrative sergeant.
Who is that?
Sergeant Thomas.
Okay. And is he the one that would have provided the videos that we have in evidence at this time?
He'd probably be one of them.
Okay. Alex, can you just play that video? Now, these videos, I think each is about 1:30, but it's an ongoing search, right? They happen one right after the other.
And is this of the 13th?
I believe this is the 14th.
Okay.
I believe. If I'm wrong, please correct me. Let me ask you while we're looking at this. So the stuff that's on the tables downstairs, is that stuff that's been taken out of cells, or is that stuff that was just left by inmates?
Without knowing exactly what date of this search, I can't see the date, but that looks like it's indicative of somebody being in the day room, inmate-wise, and then being either locked down or moved abruptly.
Your Honor, if I may.
One moment. Okay.
You can't see it, but if you were to shrink the video, the date and time are in the top left corner.
Right?
This is the video of the 14th, and the time and date stamp are on the video.
Remind me the exhibit number for this one.
This is State's Exhibit 69. All right. So go ahead, Alex. In the video there, you've just entered Ms. Richins' cell. Is that correct?
That appears to be me, yes.
And she doesn't share that cell with anyone, or she didn't, correct? She was there alone. So what is it you're doing here?
I would be looking, if this was on the 14th, this would be doing a search and then also moving her gathering up her belongings and moving it down to cell 5.
Oh, that's okay, because she was moving to cell 5.
Correct.
All right. Now, this was after you had already searched for handwritten notes the day before.
Yes, the cursive letter.
Okay. All right, Alex, it's okay. Let's go on to the next video, which is State's Exhibit 70. That's number 9. I'm just going in order. Can you zoom in a bit, Alex, on the cell so we can maybe see better what's... It's a little bit difficult, but... Okay, there we go. So what is it that you are... All right, there, in your hand, it looks like you have an envelope?
Correct.
And is that an envelope that you had looked at the day prior?
I observed it, yes.
But you didn't look in it that day?
Not looking at it, nope.
Now, is this the envelope that on the front has Ms. Richins' prior attorney's name?
I believe that would be the one.
Okay. And it says attorney privileged or something to that effect?
I don't recall it saying that. I just recall it saying Sky Lazaro, who I knew was her attorney at the time.
All right. And if a report indicated it said attorney privileged, do you have any reason to disagree with that?
I didn't see that, so...
You don't recall?
I don't recall seeing that on there. But
Okay. So on this search, you opened that envelope, correct?
yes.
And go ahead, Alex, you can just play it out well. And what was it you found in that envelope?
In inspecting that envelope, there was numerous paperwork. There was obvious court heading, court minutes. There was some what appeared to be like some cards that were made from children. I didn't observe any obvious other contraband.
There were handwritten notes in that envelope,
Yes.
correct? Quite a few, isn't it?
Yeah.
Accurate, there were a lot of handwritten notes. And you looked through those notes that day?
Yes.
Oh, I'm sorry. I know I'm bad at that. I'll try harder. All right, let's just go to Exhibit 71, Alex, number 10. Can you tell me who the other two individuals are who are coming towards the cell at this point?
That is Deputy Watts, and that is Sergeant Thomas in the bottom, and then the one in the white shirt is our nurse.
All right. Now, were you still going through the papers in the envelope at that time?
Yes.
Can you give us a rough idea of how many pages were in that envelope?
Hundreds. It was, yeah.
So, what did you do with the papers that were in that envelope after this search?
After the search, they were put back in as best as I could, back into the manila folder.
And given back to Ms. Richins?
It was left in her property and then put back in her cell when I moved her to 5.
And is it your testimony that none of the papers in that envelope were seized?
To my knowledge.
All right. Let's skip to State Exhibit 74, number 13.
Say the date again.
State Exhibit 74.
What was the next thing you said?
Oh, I was just telling Alex what number it was in our
Got it.
list. All right, I think a lot of this is frozen. Let it run and it'll start to move. Now, is that Sergeant Thomas standing outside the door?
Yes.
What are you doing during this time? Do you recall?
I recall I'm still searching the folder.
All right. At some point during this search, there is a document found that is a 6-page document that is, I believe, at docket number 214, which says walk the dog on the top. Are you familiar with that document?
Yes.
Are you the one that found that document?
I am not.
Okay. Did you view the document that day?
I cannot specifically recall. I remember Sergeant Thomas, when he indicated he had found it, that was a brief, maybe a brief look at it.
All right.
But did not get a good description of it at that time.
You read that document at another time?
Not specifically like full on, but got more of a briefing from it.
So the documents were in the envelope that you were going through. Are you aware if some of those documents have since been found to be privileged documents?
Are you asking me, were they in that envelope that I was
Well, no, right, I'm asking you if the documents that you were reading that were in the envelope contained privileged documents.
Yes, I wasn't reading them, though.
Well, you were going through, you said hundreds of documents.
Yeah.
So you would have had to have at least read some to get an idea of what they were, correct?
Inspecting, looking at, the heading on it. Like, court paperwork to me is pretty obvious, like headings.
Well, there were a lot of handwritten documents in that envelope, correct?
Correct.
And you determined not to seize any of those documents, correct?
Mm-hmm.
And as you were reading those documents, you determined that some of them are privileged and you should stop reading them, correct?
I didn't read them.
Then how did you know what they were?
Just glancing at them.
Okay. Let's go to State Exhibit 75, which is 14. And so right now you can see it appears this is frozen, correct?
It appears so. I see the timer moving in the corner, but no movement.
All right. So sometimes it detects, now it starts. So sometimes it detects movement in the cell and other times it doesn't. Is that correct?
To my knowledge, it responds on movement, so I don't know why it would be not moving or not recording.
Is that you on the left side of the bunk? I can't tell. Or are you on the
No, I'm on the right, on the foot of the bed.
foot of the bed? So what is it that you are searching at this time?
I believe I'm still looking at the items in the manila envelope.
All right. And we'll have Sergeant Thomas here in a minute so we can ask him what he's looking at.
Okay.
So I won't ask that with you. So it's still the same envelope that had her former attorney's name on it, Ms. Richins' former attorney's name on the front.
Correct.
All right, then let's go ahead and skip to State's Exhibit 76, which is 15. And if we could zoom in on the corner. Now, what I would like you to take a look at here, this video, it's frozen for some time, but then let's see what happens when it unfreezes. This is 15, right? I'm sorry, it's hard. We can't pinpoint the exact spot, but these videos aren't too long, so. It's still moving. All right, the envelope that's in your hand right there, that's the envelope we've been talking about. Is that right?
Correct.
And Sergeant Thomas is looking at some other papers, correct?
I believe so, yes.
Do you know what he's looking at
I
this
do
time?
not.
All right, then we'll just ask that to him. Let's skip to, and I believe 16, the entire thing is, I'm sorry, State Exhibit 77. Let's skip to 78. And while we're doing that, let me ask you, so when Sergeant Thomas found the 6-page document that says walk the dog on top, did he tell you about it right when he found it?
He made indication that he thought he had found something.
And did he make indication as to where he had found it?
I don't recall.
Okay.
I think he said it could have been in a book. I'd have to review my report.
Go ahead, that's. Now, I think when this eventually unfreezes, it's going to show you carrying a bin down the stairs. Do you get occasion to look at these videos very often?
Say again?
Do you get occasion to look at videos from that camera very frequently?
Yes, I have the capability to review video.
Is it always these large gaps where nobody's moving?
If there's nobody moving, it won't record.
Well, are there always gaps where, I mean, you are moving in the cell and it comes on and off? Is that how it always is, or is this unusual?
I haven't come across a situation like this.
So this is the first time you've seen big frozen gaps?
With the timer moving and no movement, yes.
So you're now walking downstairs with a bin.
Yes.
Now, did you put everything in that bin yourself, or was that stuff that was already in a bin in her cell?
I gathered her items up, yes.
Okay.
Yeah, there was items in there, but all her items in her cell I did gather.
So you put those all into the bin?
It may not have been all of them, but I put some in them. There may have been items in it already, but there was stuff added to it for sure, yes.
Are you aware of a book she had in her cell that was an LSAT study prep book?
Not at that time.
You weren't aware of it at that time?
Correct.
So you aren't aware if that is something you put in that bin?
No, I wasn't aware of what.
All right. What was your involvement after this in the rest of this search, after you searched the envelope?
To gather her items up and move it to the cell that you saw me move the box to.
All right. Did you personally seize anything from the cell during that search that was...
I did not know.
So you didn't take anything out of the cell? Everything was put back in the envelope or in the bin and moved to her new cell?
Correct.
Okay. I just have one moment. Your Honor, I don't have anything further from Sergeant Barrett.
Mr. Bloodworth?
I'm going to leave my water.
Sergeant Barrett, you're familiar with what I mean when I say the walk the dog letter, right?
Yes.
It's docket 214, but every law nerd on the internet calls it the walk the dog letter. When you searched manila envelope marked with Ms. Lazzaro's name, did you recover, seize the walk the dog letter?
I did not.
In the videos that Ms. Nestor just showed you, when you're standing at the foot of the bed, are you going through the hundreds of pages in that manila envelope at that time?
I was, yes.
Let's talk about the size of the bed real quick. Is it a normal, say, 6.5-foot-ish bed?
Correct. Metal bunk, yes.
So when you're at the foot of the bed and you see Sergeant Thomas in the video at the head of the bed, he's about 6 feet plus away from you. Is that correct?
I would say that's accurate, yes.
Thank you.
Can I ask one follow-up?
Sure.
Did you actually see Sergeant Thomas get what is known as the walk the dog document?
I did not.
Him seize that.
I did not know.
So you don't know where that came from based on your own knowledge?
Correct. I do not know.
Was Sergeant Thomas also looking in the envelope?
I did not see him look at that envelope.
I don't have anything further.
May we release this witness?
Yes, and we would call Sergeant Thomas.
You may step down, sir.
Thank you.
I might have shown not the first ones, but we'll see. Probably start 11, that's
Your Honor, while they're waiting, can you confirm that the videos was 69, 70, 74, 75, 76, and 78?
I don't know that we played. Did we play 78?
I think so. That was the last one.
That was the last one where
Sure.
Sergeant Barrett was carrying.
So there's Mr. Gabler underneath the Trial TV Live logo. There's Mr. Gabler smiling away. And of course, Katie and Clint. So there's Gabler, Katie, and
Please raise your right
Clint.
hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to fees and penalties of perjury? Thank you. Have a seat.
Good afternoon.
Hello.
Could you state your name for the record, your full name?
Jeremy Thomas,
And where is it you're employed, Sergeant Thomas?
Summit County Sheriff's Office.
And what is your position?
The administrative sergeant over the jail.
Can you lean a little bit more into the microphone?
Yeah, I'm the administrative. Do you want me to repeat it?
No, but just going forward. Thank you.
No problem.
All right. So you were involved in a search of Ms. Richins' cell on September 13th and September 14th, 23.
Correct.
Right. What happened to initiate the first search on September 13th?
The first search that I was involved in, or the
Well, were you involved in all of the searches those 2 days?
wasn't. I was only involved in one search.
Which search were you involved in?
I believe it was the second search.
On September 13th?
Yeah.
All right. And what initiated the second search on September 13th?
Your Honor, we have a day confusion. I think Thomas, as depicted in the video, was involved in the search on.
All right.
So the 14th.
So you were only there for the search on the 14th. All right, that's fine. So the search on the 14th, what was the purpose of the search on the 14th?
There was a discussion about a rule violation that Ms. Richins had engaged in over holding a letter up during a video visit, and so we were attempting to locate that letter.
Okay, so again, I don't know if we have the dates confused now. You were involved in either search on the 13th.
Negative.
Are you aware of the searches on the 13th?
Vaguely. I don't know the details of it.
All right. So is your recollection that the second search on September 13th was looking for the letter that was held up to the video?
I'm not aware.
You're not aware?
I'm aware of the I didn't see the incident, but I'm aware that she had held a paper up during a video visit.
And you're aware, or are you aware, that there was a search on the 13th to try and locate that paper?
I believe, yes.
And it wasn't located, correct?
Yes.
And just that paper had turned out to be something that was not related to this case or even contraband, correct?
I wouldn't know.
You don't know?
I didn't see the letter. The letter was never found, so I don't know.
Okay. So the letter was not seized from the cell?
No. As far as I know, the letter that she held up was not seized.
All right. So now September 14th, the search on September 14th, that was of the entire pod, correct?
Yes. Or the one that I was involved in, yes, the whole pod was.
The whole pod. So the purpose of that search was not just to search Ms. Richins' cell?
Negative. It's to search the whole unit.
Okay. And were you looking for anything specific in that search?
The main goal was to find that letter that she held up.
That had not been found the day before?
That had not been
All right.
found.
Okay. Let's go ahead and put on State's Exhibit 72 again. Now, 11.
Alex, one moment, please.
Thank you.
And
Now, before we get started, let me just ask you, on these videos, are you the one that collected these videos for evidence?
Yes.
And tell me how that process happens. How do you collect those videos?
You go to the camera and on the computer and then just download it onto a flash drive and then submit it into evidence.
All right. And have you had occasion to look at the videos of this particular search on September 14th before today?
I have seen it before, yes.
So you're aware that during these videos, the the video freezes a number of times for lengthy periods.
Yes, it could. It's motion activated, so if it doesn't detect motion, it would probably shut off.
Okay, let's go ahead and play this. Now that's you standing outside of Ms. Richins' cell up on the far right of our screen, correct?
Yes.
With your back to the camera.
Yes, ma'am.
And what is going on in the cell at this time?
Sergeant Barrett is in the process of searching some documents at the foot of the cell, of the bunk.
And those documents were located in an envelope, correct?
I have no idea. I wasn't paying attention. He would have been blocking my view of what he was actually searching.
All right.
So I'm looking at his back.
So at this time, you're not clear what he's going through, just that he's going through documents?
Correct.
Okay. Now, okay, oh, it looks like it's moving again. All right, have you up to this point been in her cell at all?
No.
All right. Let's go ahead and move to number State's Exhibit 7413 for us. You can go ahead and hit play. Okay, so let me ask you, if this is unusual based on your experience, this is playing, but it appears that it's either frozen or you're standing very, very still.
Yeah, I couldn't tell you.
So my question is, though, have you seen videos typically where there is movement, but it's freezing like this?
No, it's not typical.
This is unusual. All right, I think let's watch until this unfreezes. It does unfreeze eventually, I promise. I think. There we go. So that's the first time you go into the cell.
Correct.
And are you now looking at what? Can you pause that, Alex, right there? And zoom in. You're looking at what Sergeant Barrett is looking at this point. Well, you can see what he's looking at, let me put it that way.
Yeah, I could see. I'm not paying attention to what he's doing.
All right, but I'm sorry, I didn't mean to talk over you. Were you finished?
Yeah.
All right. You have an envelope in your hand right there, correct?
I have no idea. I can't tell what it is.
All right, do you recall, well, let's take another look. You still aren't sure what that is?
Mm-mm.
Do you recall seeing the envelope in the cell that said the name of Ms. Richins' former attorney on the front of it?
No.
So you don't know what that is that you're looking at right there? It looks like an envelope, right?
I can't tell what it is. It looks like there's papers, yes, but
okay.
I don't know if it's an envelope or not. I don't remember touching an envelope in the cell at all.
All right. So tell me what you did after this point, if you recall.
So my recollection was there on the top bunk, there was papers and books on the top, so I figured I would start searching in that area because we were looking for the document. I remember flipping through some pages on the top, and then there were some paperback books on the top bunk and the LSAT book on the top bunk. And
Stop you for 1 minute. Let me just, a couple of clarifications. So on the top bunk, there were, you said pages.
yeah, it was nothing of significance. It was like, I couldn't even tell you what they were. They were just letters, or like, it was nothing that stood out to me. So
All right. Were there a lot of pages, though, on the top bunk?
there was a few. I couldn't tell you how many, but yeah, it was scattered paper on the bunk right there.
So, on the bunk or the book? I'm sorry, what did you say?
On the bunk, on the metal part of the bunk. And then there were some books off to the side, and then there was the LSAT book on the top of the bunk right there also.
So the book was on top of the bunk?
Yeah.
All right. Let's go ahead then and look at some of these videos, because I want to see if you can point out to me where you might be looking at the books. So that was number, what was that, Alex, that we just played?
It's 13.
All right, I guess let's do State Exhibit 75. And again, this is another one that is frozen on and off.
Which number is it?
14. And if you can zoom in, Alex, up there. And then, is it frozen or is it stopped? All right, so we can't see what is, oh, there we go, it's moving. So at this point, you are looking at some papers, correct?
Correct.
Sorry, could you answer all that?
Correct.
Sergeant Barrett just had an envelope. I don't know if you saw that.
I did.
So again, even though there's movement, the camera or the video is frozen at this point, correct?
Appears to be.
We don't see you looking at any books, correct?
Not at this moment on the.
I think this unfreezes again. Oh, that was the end of it?
It's been the end of it for a minute or
All right, let's go on then to the next one.
That's why it was frozen.
Yeah, it's hard to keep track of where it starts and stops. All right, let's look at number 15, which I know a lot of this one's frozen too. But I do think it will pop on in a moment. So really what I'd like you to look at here, Sergeant Thomas, and when this unfreezes or freezes, if you can point out at any time you are looking through books up there on the top bunk. I think it's moving now, if you could. All right, now you have something in your hand. Can you zoom in on that, Alex?
I would say right there is where I'm in a book right there where I'm pulling.
Well,
I would think. It's hard to.
Yeah, it is. It actually looks like you're going through some papers, doesn't it?
I don't know. I was only in the cell for a couple minutes before I found the letter, so I would say it would be within the first couple minutes of being in there.
So your testimony is you found it where?
On the top bunk, right where I'm standing. That's the only place in the cell I searched.
So you only searched on the bunk, all right. And where was it on the bunk?
In the book, right where I'm standing.
But all of that is, none of that can be seen on the video. That's all frozen when that may have happened.
Sure, it looks like I have the letter right now, as far as I can tell.
So you have papers in your hand right now, but we don't see the book, correct?
Correct.
And those papers are the pages that everyone now calls the walk the dog document.
Correct.
Those pages, when you found them, they were glued together or stuck together as if pulled out of a notebook, like when you tear a chunk out of a notebook and papers are still together on the side or on the top. Is that correct?
I don't recall. I mean, I remember flipping through them, but I don't remember them being secured to each other in any way.
How many pages were there when you found it?
I believe there was like 8.
There were 8.
8 or 9 total pages.
8 or 9 pages.
May have been 6. There was a letter, and then it was like a check mark or like a checklist after, so I couldn't tell you exactly how many pages there were.
All right. How many pages were turned over and are part of now what are the walk the dog pages?
All of them.
Well, now actually, and this is, I'm not entering this now, but this is the letter. It's already on the docket, but just so he can refresh.
Sure.
So if you could tell me how many pages.
1, 2, 3, 4, 5, 6.
6. But there were 7 or 8 pages. Well, there were 8 pages, correct?
Correct.
All right. So, I think there were 9 pages. Did you take all 9 of the pages at that time?
I did.
So when you saw these pages that were in a handwriting, you read all of them, right?
I read most of the document on my way out because once I verified that there was something in there of concern, then I was taking them out of this section to take to my supervisor.
So the very beginning of that, in front of you, the first couple of lines, and you can just read it to yourself right now,
Okay.
is about a conversation between Ms. Richins and her attorney, correct?
No. Just saying she's referring to this guy as the third person.
Right, she's talking about something that her attorney told her, correct?
Correct.
All right, so as you started to read this, you immediately saw that she was talking about something between her and her attorney, correct?
Correct.
But you continued to go on and read it?
Correct. So I scanned the document, and then fairly quick, she talks about basically what she's telling her brother to say.
Well, I understand that's what your interpretation of the document is, but let me back up a little bit. Mm-hmm. So when you come across documents that are privileged, do you typically go on and continue to read them?
They weren't marked as privileged.
When you come across documents about an individual's case that they've written?
We scan those documents just to look for safety security threats.
You scan them or you read them?
To scan them. Or you read them until you determine that it's a legal document when it's a handwritten letter that's not in a legal folder or anything like that.
Now, you refer to that as a letter, but is that a letter addressed to anybody? Does it say Dear somebody at the top?
No, not at the top. At the back of it, it clearly is addressed to her mom.
Well, wait a minute. Let's clarify here. Addressing a letter would, there's no,
Hold on.
oh, sorry.
Go ahead, Mr. Bloodworth.
Like all the other documents in this case, It says what it says. We don't need a quiz on what it says.
Are there questions about why Sergeant Thomas did or didn't do whatever he didn't do next that you need to ask?
There is, and it's laying foundation for argument that will be made in the briefs.
If you need to ask questions about what he did or didn't do, that's fine.
Well, I think it's important to clarify, for purposes of argument and privilege, whether or not this document was obviously a letter.
Well, but you can, candidly, I don't care whether he thinks it was obviously a letter. I can address that, and I have to, under the law, make an objective determination of that. If you want to ask him why he did whatever he did or didn't do next, that's fine.
Okay. All right. Well, can I get an answer to the first question? Is there a salutation on the letter to somebody?
No.
All right. But you continued to read it.
Correct.
Anyway. And it's not signed on the bottom by Ms. Richins. It's not Love Kouri on the bottom, correct?
I would have to...
Well, go ahead and take a quick
Ms.
look.
Lewis, you just asked the next question. I'm going to move you along just a little bit here.
Was there an envelope with that to mail it?
No.
Were there any letters in her cell that were ready to be mailed out that you found that day?
I don't recall any. This is the only letter I remember. This was the only letter of significance that I felt was a violation of rules and a safety security threat.
All right, and it was attached to 3 other pages that were just notes, correct?
Yeah, it was just like a checklist it appeared to be a checklist. I couldn't really tell you everything that was on it, on the last 3 pages.
Okay, but it wasn't part, you didn't think it was part of the first 6 pages?
Yeah, I thought it was part of the actual document, yes.
All right, are you aware that the next page, page 7, was found to be privileged by the taint attorney in this case?
No.
You're not aware of that?
No.
All right, do we need to introduce, or maybe we should just introduce this? One moment, I'm sorry, Your Honor, if you'll indulge me. So this is, where's the one where he says it's privileged? 6 pages.
We can make that.
Just want to make sure it's the right one that he says, the next page.
Yeah.
Okay, Your Honor, I just want to Exhibit 158 for the record. And this is not a document that this witness would be familiar with, but I don't think I have any objection from.
Object.
What is it?
This is a letter from the taint stating that 7th page of this document.
Okay.
Your Honor, the other way, of course, to read that letter is that the first 6 on it.
Why? Either way, I don't have the 7th page in front of me, do I?
No, you don't. I can get it to you and we can submit it, but it was determined to be privileged, so the government doesn't have that either.
I've not seen it.
Okay.
And the only one that.
Sure, I'm never going to rely on this, but we'll mark it, and you can.
Well,
make
yeah, I
whatever
just
argument.
want it for the record that
Okay.
the documents this was found with were
It's been offered.
privileged.
Okay. 158 is offered.
Okay. Now, you said you don't recall if they were glued together at that time.
I don't remember them being glued together, no.
All right, then if I could just also offer, I guess this would be Exhibit 159. This is just the emails between. Just to show you the emails right. Sorry, Your Honor. After discussing this with Mr. Bloodworth, I'm going to move ahead. All right, so the only thing that was taken from the cell was this 8-page, 9-page document, correct?
Correct.
And what did you do with the document after you took it from the cell?
I took it into the jail commander and explained the contents of the letter to him, which then I was referred to take it to the county attorney's office to verify if it was a legal document.
I'm sorry, can you leave? I didn't hear that last part.
I took the letter out to the jail commander and discussed the contents with him, and then was referred to the county attorney to determine whether it was a legal document or not.
All right. And it was determined this is not the document that was held up to the video camera when Ms. Richins was visiting her mother that you were originally looking for, correct?
Correct.
So this is a different document that you took out of the cell.
Correct.
All right. And then the rest of her belongings were put, or I don't know if the rest of them, a number of her belongings were put in a bin, correct?
I wasn't there when that happened.
I think you were, actually. Why don't we put on video Exhibit 78 again?
Are we doing this to refresh his recollection?
Yes, but it's in evidence. I mean,
Are we going to ask him more questions about the bin, or can we move on?
I want to ask him what. Yeah.
Hey, Wendy.
If you can even forward. 17. 646.
What's that?
Oh.
We back that up, Alex. All right. So you are in the cell when Sergeant Barrett takes the bin down, correct?
Correct.
And Alex, if you can back up more from where he comes from. Now, he comes from behind the door, correct?
Correct.
And those belongings are things that were behind the door, it appears, correct?
Correct.
But isn't that where the LSAT book is in that bin at this point?
I wouldn't know. I was looking at the document the whole time, so I don't even recall him taking that bin out.
Do you recall coming back about an hour later to take pictures of the LSAT book?
I do.
And where was the LSAT book when you took the pictures of it?
I believe it was down in that property down there.
It was in the bin, correct?
Correct.
And did you take that book out of the cell and put it in the bin?
No, I don't know if Barrett must have grabbed it, or if he grabbed it later and put it in there, or if he grabbed it like while I was reading the letter.
Well, shouldn't that be on the video? If he put more things in the bin?
Yeah, I'd imagine.
All right. Your Honor, you'll have the videos. So he doesn't recall. I don't want to just sit here and show every video. But
Well, to be clear, I don't know how many of these there are, but I'm not going to watch all of them unless you have determined that one of them is relevant.
All right.
You can just proffer which one you want me to watch, but
I'd like to proffer a negative. There is not a video of anything else being put in the bin after we see the bin coming down the stairs.
fair enough.
So, and there's only a few videos after this. Okay. But so there is a video, though, of you pulling the book out of the bin, correct?
Correct.
And taking a picture of it. All right. Let me see. We don't have anything further. Thank you.
Mr. Bloodworth, any redirect for a sergeant?
Yes, Your Honor, thank you. Mr. Ramos, rather than switch computers, can I get you to bring up a video?
Yeah.
Can you bring up video 84?
84?
Yes, Exhibit 84. It's the second video, number 22.
Yeah, it's the second 22.
One down.
I actually know it might be the top. But let me look.
Sergeant Thomas, we'll just pick up where Miss Nestor.
Lewis. I let you get away with it once.
I apologize.
It's all right.
Where Miss Lewis has left off. Take a look at that video. What is this depicting?
Me grabbing the book out of the bin
And why are you grabbing the book out of the bin?
so I could take a picture of where I found the letter.
And by book, you mean the LSAT book?
Yes,
And why did you want to take a picture of where you found the letter?
to book it into evidence or attach it to the report of where I found the letter
Okay.
because I stated it in my report.
Is that the LSAT book in your left hand where you found the letter?
Yeah, it looks like it.
Is this you using your cell phone to take a photograph of that?
Correct.
And is that the photograph that, if you know the number, but is... It's found at 86 in the court's binder. We can show you that photograph. Do we have it real quick? Connor, can I borrow the course binder to show?
All right, well, that just cuts off awkwardly, so sorry about that, you guys. All right, we're going to next watch, we're going to go back in time. So this is going to be from November 3rd of 2023. This is a hearing with Sky Lazar. Lazaro? Lazar. Is it Lazaro or Lazar? I should know that, right? Sky Lazar. Lazaro. All right, so this is from November 3rd of 2023. So this is when they first tried to talk about the admissibility of this letter. So they're going to talk about, I think, a lot of things, but I think part of it is the admissibility of this letter. So I'm kind of jumping around today, but today's been one of those days, right? All right, so now this is going to be from, they should talk about walk the dog as well, but they might talk about a few other things. So this is from November 3rd. All right, so let's check this out.
And due process rights as it relates to the alleged witness tampering, right? We would be able to cross-examine people, she would get a trial, we'd be able to present witnesses, we'd have arguments whether or not evidence was going to be admissible or inadmissible. The problem with the way the state has characterized this in their briefing is the fact that they have definitively said she's guilty of it without being afforded any of those. And I think being charged with something is different than the state saying she witnessed tampered. This isn't the first time she witnessed tampered. This is further evidence of witness tampering. All of those things. And then they go on to say, you know, not only did she witness tamper, but because she witnessed tampered because she's guilty of murder. Like her witness tampering is a consciousness of guilt. And I can pull it out of the briefing. We prepared it in slides, but that's the problem, and that's the violations of rules 3.4, 3.6 in the UBA standards. Is you can allege some through a filing. or through a criminal complaint, right? She's here today because the state's alleged that she committed a number of crimes.
Sure.
Right? And she's going to get a preliminary hearing, and we're going to go through this entire process before we get to say she's guilty or not guilty. And the problem with the state's characterization over and over and over again, and in fact it got progressively worse or progressively more definitive in their statements that she is guilty of witness tampering, and that's the narrative that the media has picked up. And I think that's the violation of the rule, not, if they had charged her with it, you're right. But also then have the opportunity to refute that or go through due process rights. But by just saying she was guilty of it, and by saying she was guilty of it is bad. By saying she witness tampered as a consciousness of her guilt is worse. By saying she administered the fatal dose of fentanyl is worse.
So
and they're tying all of this together.
A lot of that water went under the bridge as of the detention hearing. That is their theory of the case, that there was a financial motive, there was poisoning, caused the death of her spouse. I mean, that's the case. Then we have requests for things like don't let her talk to certain individuals because, and then once we get into the because, their justification for the request is we're concerned that she's trying to alter their testimony at a future trial. Stated broadly, everything I just described is part and parcel of lots of criminal cases.
Right, except for the fact that they go further to say they have a theory, right? It's in the probable cause statement. It came out in testimony at the detention hearing. You're right. That happens in every single criminal case, and we can cross-examine people and weigh the credibility of witnesses as we go through. Okay. The problem is in their briefing, they dispel or they characterize the defendant's alternative theory or perhaps a potential theory of the defense as a false narrative, that it's a lie, okay?
Sure.
Which completely diminishes the credibility of anything we say. And then they've gone on to say, and all of her witnesses are lying, and she's telling her witnesses to lie. So now we're in a position where anybody we put up there, a jury pool is going to say, well, I mean, she witness tampered, so obviously these people are lying. And the state's already said that anything she says is a false narrative because it doesn't fit their theory. That's a problem, and the rules specifically prohibit the state from commenting on the theory of the case or on alternative theories of the case or on the credibility of witnesses.
And trying to determine where the line between permissible advocacy and impermissible communications that would irreparably damage the jury pool. I acknowledge that however long jury selection was going to be at the end of the detention hearing, it seems like it's 3 times longer now.
All right, so sorry, Judge, to capture you in such a all right, you guys. So Sky Lazaro was Kouri's first attorney, and she was through the walk the dog letter because we clearly see that in the walk the dog, right at the very beginning, Sky is saying even if the gummies have. So Sky was her first representative, first lawyer, and she got off of it because Kouri wanted Sky to bring her teeth whitening crest whitening strips or something like that. Teeth whitening strips. So she wanted her to bring in contraband. So that was I think one reason. There may have been other reasons. Maybe this letter also, I think probably she didn't like either. But yeah, so this is Sky Lazaro. This is Kouri's initial set of representatives.
I'm with you. I got it. But why can't we, through a combination of lengthy and careful jury selection and instructions to whatever jury gets selected, mitigate the harms that you're describing?
answer this in two ways.
Sure.
Okay, the first one is, I want to address first is the rules. The rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar and the witnesses are liars and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules, like period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules. I think what you're getting to is a potential remedy, and I think the prejudicial effect is that this is everywhere. We pulled, I mean...
But it was everywhere long before this.
It was, but it was everywhere before the state started making these comments. It was going to be everywhere. I don't think, I mean, I'm not going to sit here and say that all of, this wouldn't have happened or there wouldn't have been news stories. Sure. There would have been news stories about this case no matter what we did. And I think that's a given. The problem is now these news stories have adopted the state's interpretation of the letter. And the news stories have run with...
Accurate? I mean, I have assiduously tried to avoid news coverage of the case just to make sure that my consideration of it wasn't polluted by any inaccuracies in the popular media. But even I bumped into the cover of People magazine, which seems to indicate or have at one time been providing a counter-narrative that seems to be provided by the defense side of the debate. I mean, why isn't this a case of both sides airing their competing narratives to the fullest extent they believe is permissible under the rules?
I think you can advocate, but I think it has to be within the rules. And when you go so far as to essentially say she's guilty of witness tampering, and because she witness tampered, she committed murder, and the Today Show pulls a snippet and puts it by her face that says she told these people to lie about whatever it is, that's a problem. And I think that goes a step too far. Yes, we can all effectively advocate. We're going to do it through briefing throughout this case, I'm sure. But I think there's a line in what you can say, and I think the rules are very clear on it. And when the state starts making conclusory statements about her guilt, about the credibility of her witnesses, about her credibility, about my credibility, I don't think, and then the narrative becomes, and the comments that we pulled are, she's guilty, she's, why are we even doing this? This is just a box to be checked. Like, these are local comments. And yeah, you're probably going to get some of those, but the state has taken it a step too far. And the other thing I want to address is there was an alternative method to this. And in the ABA comments, this goes to the second part of your question, 2 questions ago, regarding, if they think she witness tampered, can they bring a motion and ask the court for relief? The answer is yes. Okay, I think we can agree on that. The problem is in the way they characterized it and the statements they make in their brief. The second problem is our position is it should have been done differently. And the ABA comments speak directly to it, and it's 8-2 point, one second, I'm going to get there. I can only remember so many numbers. Point 1. And what it says is, a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing the standard. If the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interest, the lawyer should consider seeking a sealing order pursuant to standard
Pause there for a minute.
8.2.
In order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, she can't get a fair trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that. I
mean, can we just acknowledge that during trial, the options are so limited. The jury's already in the box. We can't re-impanel.
Right.
Jeopardy's attached.
Right. I think that is a different scenario. I think some of the cases, though, that came back on appeal, right? Like, it didn't get dismissed during trial. The conduct occurred, prior to trial. And those cases came back on appeal, for a new trial.
Those were embezzlement kickback side deal, right? Not pre-trial publicity cases.
Correct.
Am I right about that?
Correct.
Okay.
So I do think it's nuanced, or it's difficult in these cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and the statements they have made, have not done that. And the prejudice is we can't undo that, okay? This letter is out there forever, right? Whether it's ultimately admissible at trial doesn't matter at this point.
It matters a little bit, doesn't it? Because if it were to come
I'm going to
at
argue
trial,
it matters because I'll probably move to motion to suppress it, but...
Well, sure. Yeah,
Right.
So, and I'm not expressing an opinion one way or the other about any kind of motion in that regard, but imagine the letter came in at trial. Any pretrial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
The problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations,
sure.
Right? And yes, we can get to that through cross-examination and
if it comes in.
Or, at trial.
Right.
The problem is that there is local, national, global media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Kouri's lying, that her witnesses are lying, that her theory is false, that's the problem. The problem is their statements and the way they've interpreted it, and the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but I don't think that's sufficient given the egregiousness of the statements. If it had just been, the way it should, in my opinion, the way it should have been done, or the state's or the defense's assertion is they could have moved the court for a motion for a no contact order. They could have filed it under seal. They could have filed the letter under seal. We could have had this argument or in a way that wasn't the state saying that she witness tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems, and those aren't going to go away. Forever there's going to be this issue that the states said that, and they can't do that. And if the courts, and I granted, dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue, given the egregiousness of the statement.
So I looked at the defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue yet. The dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by the BBC. I don't know that you will find a jurisdiction that is, certainly not the state of Utah, that is going to be materially different than Summit County in terms of its saturation with media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're fairly early in the process of this, so I do anticipate moving for a change of venue. Based on, I agree. Unless we're going to some tribal land in Ghana, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court's attention that we believe would support a change of venue. We don't need to get into that today, but I do anticipate that will be coming.
Then we have disqualification of the Summit County Attorney's Office, and I'm not sure why that follows. Here, at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else? Well, they've been involved. They're going to be subject to whatever ruling they make. I don't understand why disqualification of that office based upon public comments, conduct they've taken in prosecuting a case, making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now they know, and I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why, though, on a going-forward basis. What is it about the continued involvement of the Summit County Attorney's Office on a going-forward basis that would be prejudicial to this regime?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements. And I think that's a problem. Further, they've been involved in the investigation. Allow me a little more. Thank you. So, when they began investigating this case, I was having communication with the Summit County Attorney's Office. So they've been involved since the very beginning of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and the defense theory's got to be a lie because it doesn't fit with our narrative of facts, right? The problem is there's an insinuation that perhaps they drove the investigation, and this is where it ended up. And if it's
tell me what you mean by that.
Well, they made the ultimate conclusion that she's guilty in their briefing. Okay. And they were involved with the sheriff's office throughout the entire investigation, and they're saying that any alternative theory, say we go out and investigate and have investigators working and come forth with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, maybe they didn't go look for any. I think the implications of...
That's a great closing argument regarding Ms. Richins getting railroaded, but I'm not sure that justifies by itself
I think
disqualifying the Suffolk County Attorney's Office.
I think in order to fix the narrative that the state has put out there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only, the only way to correct the violations that we've alleged is to say, you know, that they made mistakes, they violated the rules, and therefore they're not on the case. I think that puts us back a little bit to center, where now we can go forward and we can present theories, and there's a message out there that says, look, they shouldn't have made those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that the
Isn't that problematic as well, though? Or are we sending a message? I mean, we'd have to exclude all the jurors that had any sense of that, whether we're going to draw any conclusions upon that. We need potential jurors that were agnostic about that, wouldn't we? Meaning they didn't have an opinion one way or the other regarding the motives or conduct of any of the participants.
Right, but there's still, I don't think without proper remedies from the court, it restores Kouri's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses. I mean, we're going to call witnesses, but, you know, we're on the presupposed motion or assumption that, you know, the world has taken that they're liars because that's what the state said. And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason, right? So you shouldn't be able to say it now.
Well, I mean, let's be more specific about that. If they wanted to get up and say that, for example, if Ms. Richins testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C. The inconsistency shows that X, Y, and Z is a false narrative. That is proper closing argument.
Right, but it'd be based on evidence.
Fair enough.
Right?
Yeah.
And you could, that is, I mean, that's what you advocate in closing arguments. You can say, you know, we presented this, the jury gets away the credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through a lens that they're lying, to look at Kouri through a lens that she's lying, to look at Kouri through a lens that she is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, you know, I'm doing nefarious or criminal acts is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out things that are materially prejudicial. So I think that answers that question where they're making these statements now. 3.6 in the comments specifically says these things are materially prejudicial. And those are the things that they've done here.
Okay. I understand your position. It won't be the last time you get to talk. Let me hear from the state. Was there anything else you wanted to put on the record in the first place?
No.
Okay. Mr. Pleasant.
Good afternoon, Your Honor.
state's briefing was a little general in terms of we haven't done anything wrong, there's no prejudice, let's just move on. Address Ms. Lazaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things the state would be allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record today. And that's an important point here, is that consistent with First Amendment jurisprudence on public access, consistent with the court's rulings on public access, these are public debates. These are the debates where the state makes its case in a filing, and the defense has an opportunity to rebut that case in the filing. They've just rebutted it, not only in their prior filings, but right here, right now at this podium. And that is fair litigation. That is how cases are litigated in criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection we will need to identify jurors that have no knowledge of a whole long list of things, including the briefing and media coverage regarding the walk the dog letter and the manila envelope and any number of other things?
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. That will take a jury pool larger than normal, an enlarged questionnaire, expansive voir dire. But there are people in Summit County who are not following this case, at least a dozen or so. And there are people, who we can see as very impartial. Summit County Court set a jury that went to Paltrow matter that received tremendous publicity. The court was right to note that much of this publicity is both national and international. More so probably than Summit County. I can think of two pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see Summit County juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having, the Algiers case that I can remember was the state or the defense cites in its briefings, in dicta makes, I think, a pertinent note that the publicity at issue in the prosecutorial misconduct and retrial motion was kind of a drop in the bucket to the overall publicity that the case received over the arc of time. That's where we are here as well.
Okay. Anything else from the state on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you, sir.
Ms. Lazaro.
There are a couple of things I'd like to address.
Please.
With so answering. The first point I'd like to bring up, and we addressed it in our briefing, is the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. Essentially, What they say is it maybe doesn't matter, that this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by evidence in closing argument. What they can't say, and I think I'll just pull out a few of the ones that I think are particularly problematic, is, they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering, essentially implying that she's witness tampered before.
Right, but I come back to the hypothetical if they had just charged her.
But they haven't, that's the problem.
I know, but isn't that better for her?
Well, yeah, I don't want any more charges,
Right.
I agree with you.
But isn't it a proper exercise of prosecutorial discretion to say, that is a distraction to prove that lesser charge? We're going to focus on the top level charges that are in the information.
Absolutely, absolutely. And I don't...
So the only reason I raise that is to say, in that alternative universe that I am describing my hypothetical, the information, the preliminary hearing, all that stuff would be transmitting the message, she's a witness tamperer. That is not different than we have here. It might be worse.
It might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she'd ever passed the letter or witness tampered, right?
Right.
So we would actually get to stand up here and say or cross-examine people to essentially prove that that wasn't true.
Well, that's probably not to
and I don't
too
want
far in the direction,
I don't think
but
that
why
matters.
I'm disinclined to prevent her from talking to her mother and her brother.
Okay, but the issue is that they have just declared that she's guilty of it, right? Instead of...
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's been charged?
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used the way they've drawn the inference between witness tampering and the ultimate decision that a jury is going to make in this case after it hears evidence is that because she witness tampered, it's a consciousness of guilt. She induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard on which I relied during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct. I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, admissible or otherwise, showing consciousness of guilt? Why isn't that a proper conduct rather than improper conduct, whether it gets media attention or not?
Because the rules specifically say that they can't comment on her guilt. The rules specifically say you can't comment on the credibility of her witnesses. The rules specifically, it's clear in the rules. It's very clear in the rules what you can't do, and that's what they've done here.
But you're not suggesting that the rules prohibit, as a matter of law, making an argument regarding consciousness of guilt in a pretrial finding?
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase, consciousness of guilt, in a number of different ways that doesn't say she's guilty of witness tampering, we're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, she's doing it because she's guilty of murder. And that's what you can't say. You can't go that far. Yes, there are probably a number of ways you could argue that in different ways that may not violate the rules. But the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the ABA standards essentially say there's different ways to do it. Like you could have done it under seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue where we're not working, or it's limiting our ability to work on other things. We're doing this. Ultimately, this rests on, or what's alleged, she violated jail procedure policy. They make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative with the state's position on her guilt and the credibility of her witnesses. And I think I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial, though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you've impaneled a jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. But it's still, and maybe these don't get litigated. I don't know. I mean, I don't know the answer to that. Maybe I don't know how many people, how many arguments are had. If this were a case without a lot of press, okay, if this were normal course, like my 60 other whatever cases I have, right, that are going through the courts, sure, we litigate things on the record, but nobody's looking at the record, right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because, nobody would see it, right? The jurers, we impanel juries all the time that have never heard of my clients and have no clue about anything that happened, and they go about the normal course of business. And so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think we see most of the case law come from that, because that's how majority of the cases go. This case is different because this case has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, jurors that have likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of, I mean, obviously we're here asking for a dismissal, but alternatively, without grave sanctions against the state. And we suggest that they be removed and this start over or continue forward, that's what I should say, with a clean slate, in order to, put some order back in and, go back and ensure her fairness, her right to a fair trial. these premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not we can ensure that she gets a fair trial. I think that ultimately is the most important thing in a criminal case. It's, you know, the lofty reason a lot of us started doing this in the beginning, because we were going to be a champion for the rules. But and I don't mean to make light of that. I think that's true for most of us who do this. But it is the most important thing. And so it can't be just, well, as the state says, like, too bad it's out there, we're just going to keep going, it's fine. It's not fine. It's not fine because they violated the rules, and the result of that is worldwide prejudice and a world that thinks that her liars, and her witnesses, and her counsel, you know, are going to misrepresent things to them or lie to them. And that's a hard thing to remedy.
I understand your position.
Thank you.
Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richins' ability to speak with her family members, have included statements that violate Rules 3.4 and 3.8 of the model and Utah Rules of Professional Conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and the breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt with respect to certain explanations made by the defense for certain actions, that no such link exists in the evidence, that defendant concocts a false narrative, that defendant's own handwriting, she attempts to induce her brother to testify falsely, that she is facilitating witness tampering and supporting a false factual narrative, that she is giving her mother instructions to induce her brother to testify falsely, that this may indeed not be the first time the defendant witness tampered, and that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting the view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richins, her credibility, the credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richins' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection. We will need to identify jurors that do not have any preconceived notions about the subject matter of this case or any of the people involved in it. The parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given the pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richins actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge and there was probable cause to bind her over for trial, and these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct of the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richins a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient voir dire process to ensure that Ms. Richins does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied in full. All right. Any questions, Ms. Lozano? Mr. Blood?
No, yeah.
All right. Let's move on from there. Let's go to the no contact order. The motion for no contact order. Mr. Bloodworth, you probably had this sense when we last discussed this, but I am disinclined to limit Ms. Richins' ability to speak to her mother and brother for several practical reasons. First, I've got to swim pretty hard upstream against the First Amendment to enter that kind of work. Second, there are several non-criminal case related issues that she probably needs to be talking to her mother and brother about, and those are implicated in many of the motions and issues that are being raised in the civil cases, the estate case and the wrongful death case. And so if I gag her in this criminal case, I'm prejudicing her in those cases. Moreover, the cat's out of the bag. You know exactly what she's saying to them. All her jail calls are recorded. You have the letter. You're asking for the narrative. I don't understand what the prejudice is here.
Your Honor, let me take a second crack at it, and we'll, in the course of this explanation, get to the prejudice. Your Honor, in a sense, the court has its hands on a dial. And if it turns the dial in one direction, it can amplify the protection against witness tampering in this case. If it turns the dial...
Assuming any has occurred, right?
I'm going forward.
Okay, fair enough.
Going forward.
Yeah.
If the court were to rotate the dial in the other direction, it could more narrowly tailor the prior restraint. And they're correlated, right? So if you amplify the protection, you're going to have a much broader prior restraint. And so when the state first asked for the no contact order, a lot of water under the bridge since then. When the state first asked for the no contact order, it asked for a lot of protection against future witness tampering, which also meant that prior restraint wasn't very narrowly. I think we're at a point now, having all learned a little bit over briefing and argument before today, including today. Based on where we stand now, the state would kind of adjust the dial, accept some risk to future witness tampering in order to more narrowly tailor the prior restraint. And I recommend, to accomplish all of that, to include the necessary communication you referenced in your question. I think a more reasonable and appropriate order reads something like this: that the defendant shall have no contact with her mother, Lisa, and her brother, Ronnie, regarding the criminal case outside the presence of counsel. That would allow any necessary contact to prepare her defense. That would allow, in fact, necessary conduct with her mother and brother to prepare her defense, but it would place counsel there to ensure that it was just preparing her defense. Then the order would read, any or all contact outside the presence of counsel will be either through an in-person visit at the jail or through the jail's home wave applications text feature. And I say this because there is a monitoring component involved. The state is having to monitor the defendant to ensure going forward there is no witness tampering. And the state thinks the restriction on in-person and texting allows monitoring kind of without gaps. When we get into monitoring hours of phone calls, there are gaps.
Status quo right now, a defendant in the Summit County Jail is getting a notification when they make a phone call that it may be recorded, right?
Yes, Your Honor.
In-person meetings, are they notified that those may be recorded?
Yes, Your Honor. They are audio and visually recorded. The inmate and visitor are both notified.
And status quo, the inmate can't pass anything to a visitor, correct? Outside of counsel. We'll get into that in a different motion, but is that correct?
Yes, Your Honor, that's correct.
Okay. So why do we need to be so specific? It feels like the Summit County Jail is providing all the protections you need to figure out what's being said.
Had a lot of time I put in inspection the state, which is part of housing somebody. I appreciate that.
And prosecuting them, yeah.
And that risk that we're missing something.
All right. Okay, I understand your position. Thank you. You'll get the last word. I'm sorry, Ms. Lazaro, is this one yours?
Yes.
Just level with me. Do you think there's any part of this motion that I should grant?
No.
Okay. All right. Is there anything else you want to say about it?
I think it should be denied, and I think that I'm just going to reiterate the problem is that the entire thing is premised on their accusation of witness tampering, which they have failed to prove.
Well,
I mean,
perhaps we can acknowledge that there are several plausible readings of the walk the dog letter.
yeah, if the court wants to.
One of the several plausible ones would be consistent with the state's version.
Correct.
Okay.
And one would be the defense's
Agreed.
version, and
I guess what I'm saying is, why do I have to figure it out?
Well, you don't, and that's the problem. You shouldn't
Okay.
have to. Like, that's the whole problem with all of this is they're alleging a crime without any sort of due process or without any sort of evidence to support it. And the fact that that letter
There's some
could or
evidence. I mean,
couldn't-
a letter exists.
A letter exists, yes, but there's no indication in the reading of that letter that that letter could be written in the lens of these are the people who are going to testify. I want them to remember these things, right? And that wouldn't be witness tampering. She can completely do that. Also, that letter was never passed or showed, and the inferences made by the state is just because she held up one letter that she must have was going to do it with this one, and that's the problem. Like, they have not made a showing that even comes close to a probable cause finding for witness tampering. And I think there needs to be some acknowledgement, if the court's inclined to deny that there isn't a finding that happened as part of it.
I think it's probably more important for me to make no finding whatsoever on that, isn't there?
Yeah.
Okay. I understand your position. Mr. Blood Relief, producer. Okay. Issue before the court is the state's motion for no contact order that seeks an order preventing defendant from having any contact with her mother or brother to prevent further tampering with testimony. The state has narrowed the relief it requests today at oral argument to say that defendant should have all in-person, or request that defendant have all in-person meetings with her mother or brother with counsel present, and that other communications be monitored in specific ways through technology available at the jail. First, the defendant has a First Amendment right and to correspond with whom she pleases and to say what she likes, as long as she doesn't do anything that requires a prior restraint justified by a sufficiently strong interest that countervails her First Amendment rights. Here, there's no evidence that she's done any such thing that requires her to be prohibited from speaking to any specific human being. The Walk the Dog letters have several plausible readings. It does not include any threats whatsoever or any other kind of communication that would typically justify a prior restraint on free speech. Moreover, there's no evidence that it was ever handed to anyone. And the state hasn't. So to the extent they need to cross-examine a witness or impeach a witness with its contents at trial, they would be able to do so absent some other ruling by the court excluding the letter or suppressing the search that found it. Moreover, the status quo is that defendants' communications with everyone, except her lawyer, are monitored. They're recorded. And the court's in no position to make that job easier for the state. So the court is simply not presented with a sufficient basis to restrain Ms. Richins' First Amendment rights. The motion for no contact order is respectfully denied. Okay. Anything further there, Mr. Clifford?
No.
Ms. Lazaro. All right. Ms. Lazaro, the motion to enforce order for contempt sanctions, have I sufficiently addressed that in reaching the conclusion on the motion for prosecutorial misconduct?
Yes.
Okay. The court is hereby denying the defendant's motion to enforce order and for contempt sanctions based on the same reasoning that justified the denial of the motion for dismissal based upon prosecutorial misconduct. Let's turn next to the state's motion to compel good cause disclosures. Ms. Lazaro, can I start with your team on this?
Sure.
Is it you?
Well, I guess until I need a lawyer, it is.
There's a 60-page document. I have no idea what's in it. You assert it's privileged, correct?
I don't. There is a folder or a manila envelope that Ms. Richins kept in her cell.
Right.
That contains a lot of pieces of paper.
Okay.
Okay. As far as whether a document. Our assertion, yes, is that everything contained in that is privileged by way of it was given to me, it wasn't given to anybody else, it wasn't published, it wasn't, nothing else was done with it. So yes, that's our assertion.
So the defense asserts this 60-page or 60-something page document is privileged. The state asserts it is not and is material to their case because, depending on which version of the explanation you focus on, it reflects a partial factual, partial fictional narrative. Typically what we do is in-camera review and then allow the parties to make arguments regarding the content of the document and have a legal ruling about whether it is in fact privileged and subject to disclosure if it's not. You have access to the document, so you're in a good place to make those arguments. I can't ask the state to argue about this with one hand tied behind their back. So, do we give the review attorney access to the document with a strict order that the review attorney cannot share any of the substance of the document, certainly not the document itself, with anyone from the state, and then have a sealed proceeding by which your team represents defendants' interests on this issue, the review attorney represents the state's interests, and then I make a determination?
We could do that, or the court could do an in-camera review. We, as a team, kind of reviewed and discussed this. This kind of came up last minute as far as putting it on today. And I guess I'll put this question to the court. Part as to how you want to go far enough. Part of our, I think, concern or things we want to address as it relates to privilege is how and where it was found. And if the court is just simply inquiring as to the contents of the packet itself.
Well, but would you acknowledge that just putting a document in an envelope labeled attorney-client privilege and handing it to your attorney and no one else, that's not sufficient? If you put a takeout menu in that envelope and hand it to your attorney, the takeout menu is not an attorney-client privilege communication.
That's correct. It wouldn't be, but this isn't a takeout menu. These are her handwritten notes.
I know, but
So-
I don't know what they say. So if they are in fact a fictional narrative where she's just writing a short story, I'm not sure they're privileged at all.
Well, I think.
But I'm also not sure they're material. So
I was going to say, I think it needs, before anything, whether it's reviewed by the court in camera or whether it's reviewed by Mr. Jordan, I think there needs to be a twofold analysis as to what and what not is privileged, and then what and what not may or may not be relevant before it's turned over to the state for review.
I agree. What I am reluctant to do is make that determination in a vacuum without the benefit of advocacy by the defense and the state. And so I agree with you, though. It's a two-part determination. And the privilege issue is a gate. If I determine that it's a privileged communication, it does not get produced, no matter how material it is. All right, let me ask the state about this. Mr. Bloodworth, you see where I'm headed here procedurally. Any objection?
No, Your Honor, that's what the state asked.
It was unclear to me, though, whether you were asking for the review attorney to just make the call or have only the review attorney brief it. But what would need to be clear is the review attorney would have access to this, would be the state's agent, would represent the state's interests, but none of your team and none of your office, nobody else in the executive branch could have access to the document or disclosure of its contents.
Correct,
Until
Your
I
Honor.
made the ruling.
Your Honor, I'd back off a little bit of what you said and say the review attorney is not the state's agent, he's a neutral. He was selected by the defense counsel.
Not in my proposal. My proposal is the review attorney represents the state on this issue. Because Ms. Lazaro and her team are going to be making advocacy arguments on behalf of the defendant that I imagine go in the opposite direction.
Well, Your Honor, I imagine the state, too, would present advocacy on its behalf, at least to the threshold matter of privilege.
How? You won't know what's in the document. So you need a lawyer that has access to it, and it can't be a member of the litigation team.
No, Your Honor, to some degree the state does know what's in the document because the state has listened to jail calls where the defendant describes in great detail what's in the document. And that
Maybe, but we have no idea if that description is accurate or not. The document speaks for itself.
Correct, Your Honor, but how the review attorney interprets the document will depend on some measure in the defendant's characterization of it. So the state...
Fair enough. And so will the defense have to navigate those waters.
Yes, Your Honor. The state envisioned and asked for a procedure with the review attorney or the court. We asked for it in the alternative, whereby both the state and defense can present legal argument based on whatever facts they know as to whether or not particular material inside the envelope is privileged. And then he can make a threshold determination on privilege. And then once we're past that, there may be a material determination.
It's not the way this usually works. I mean, candidly, where you're describing hamstrings on both sides. I'm not even sure it would be reviewable if we did it that way. Why wouldn't we just have the state designate, I imagine it would be outside counsel, who for this specific task is walled off from the state's prosecution team? When I represented members of the media, this is how we did it. Right? Like, I can't share any of this information with the reporter, but I can argue why they should have access to it based upon the content of the document. Where do you see the error here?
Your Honor, the state's agreeable to pursuing it in the fashion the court described. I've seen it work both ways. I think the what you described is perhaps more common in civil litigation context than in criminal one.
Sure.
And I'm fine to proceed. The state is fine to proceed in either fashion. The state's the thrust of the state's argument is
The material needs to be reviewed by a neutral. The defense alone cannot make the privilege determination.
I don't disagree.
And whatever procedure the court prefers to accomplish that, state of the state.
Okay, I appreciate that. Have a seat. There's a lot of chatter over there, Ms. Lazardi.
Sorry.
You feel like we need to go in a different direction?
Just, I guess, 2 points I'd like to make. Given that the court is viewing the review attorney as an arm of the state, our preference would be that the contents be reviewed in camera for at least the initial.
Maybe I'm wrong about that. Forgive me. I mean, the existence of the review attorney,
Generally speaking,
their identity was new to me until I read the briefing on this issue, right? And so it doesn't have to be the review attorney, but what I am trying to avoid is, on the one hand, the court making this determination without the benefit of the adversarial process.
We're not asking for that. I agree with the court's proposition as to how to move forward, and that it first get reviewed for privilege, and then we address materiality of it. I don't think when we're talking about the first step and the privilege, if we're arguing about whether or not certain things contained in there are privileged or aren't privileged, the state, it's the counsel here today, should not be able to make those arguments because it negates the whole point of privilege.
That's my point.
Okay.
And so that's why I think they, in my version of the procedure, need to have an outside lawyer whose sole role is to make those arguments on behalf of the state.
Right. And we have identified Mr. Jordan as an agreed upon review attorney.
Okay.
As it relates to that. So I guess I'm envisioning probably 2 separate processes. We have a hearing on, or at least briefing on privilege, and then a briefing on materiality.
Yeah, maybe we can just do it all at once. I don't know.
Well, I guess, yes. Well,
if you're going to review the documents,
that's
we're
fine.
briefing this.
That's fine. The other thing I just think is an important, like a side note, and this is probably going to come up in the briefing, the jail searched that packet multiple times and passed on everything in it. It was, and I'm just bringing that up as, and like I said, it'll probably come up in argument, but you know, they've already, you know, they have been through it. So.
I'm not sure what the significance of that is, but I don't know that I need to.
Yeah, we don't need to get in it today.
Okay. All right. So.
Do you have any other questions?
No, I have some practical questions for the state. And if you're not prepared to answer them right now, Mr. Bloodworth, I'll understand. I'm moving this issue in a direction maybe you didn't anticipate. But are you prepared to stipulate that the review attorney, Mr. Jordan, will be the state's attorney for the purposes of this walled-off review of the 60 whatever page document? Or do you want to designate a different lawyer and keep the review attorney separated for future tasks? Maybe you're not.
Your Honor, I want to consult with my team briefly on this, and part of the reason why is the review attorney is already engaged on other reviews.
Right. Okay.
And so my sense is we need a new attorney.
Maybe so.
That I don't want any of his other reviews to
be affected. Okay. Why don't we're going for about 90 minutes. Why don't we take a 15-minute break?
Before we get there, can I just make one more point?
Sure.
I think before we get to the point of whether or not they're privileged or not privileged, we need to address whether or not we should be compelled to turn it over to start with.
That would depend upon materiality, right? I think that's right.
I mean, I think the state needs to make a showing as to why they think they get this packet, first of all, right?
Well, all right, so let's put aside any issues of whether the way the document came to the state's attention is appropriate, should be suppressed, excluded. Put that aside. I don't have any motion like that in front of me.
Okay.
The state knows about it. They know some things that they that Ms. Richins has said that they think refer to the content of the document. Don't know whether or not they're accurate. We'll find out. Whether the defendant has to turn it over under Rule 16 will depend upon whether it's material, right? Whether there's good cause for the disclosure. Hypothetically, if she's like, here is a timeline of how this went down, and just gives a list of admissions, and somehow it's not privileged, right? That's the kind of thing that would need to be handed over. If it's, here is a short story about Care Bears, I'm not sure it's the kind of thing that needs to be handed over. Do you see the law differently?
Well, I guess in my mind we need to go back a step. I mean, we're talking about whether or not things are privileged or not privileged, and then if they aren't privileged, whether they're material. Before we get to that, I think the state needs to provide a good cause showing as to why they think they get it, and I think it doesn't. Before we ever get to any of those steps, like,
well,
why?
I think they would say they have a sufficient threshold to trigger the privilege review based upon the portions of the recordings of Ms. Richins' jail calls in which she says this is part fictional, part factual. Am I summarizing that correctly, Mr. Bloodworth?
Yes, Your Honor.
And so there's a reasonable inference in the state's view that the parts that are factual are backward-looking statements about what happened. They're factual. We'll find out. But there's at least enough that the state has presented to trigger your need to assert the privilege, maybe move to suppress, I don't know, and then to trigger the related materiality review. You see it differently?
That's fine.
Take a recess.
Why don't we take a recess?
Yeah.
Okay, sounds good. Listen, there's a lot of people in here, so if you need to get up and move around, that's fine, but it's 15 minutes. So if you don't want to get locked out, consider staying put. We'll be back at 3:20. Thank you very much.
All rise.
All right, I'm going to go ahead and fast forward through this because there's certainly no reason to not fast forward. So again, this is from November 3rd of 2023, and this is about the walk the dog letter, admissibility of it. They're talking all about Kouri getting a fair trial. I'm just going to fast forward through here. So for those that are coming in late, live court ended, when did they end? Like 1 o'clock or something, 1:30? Because the defense wanted a continuance. They wanted a 2-day continuance. The judge gave them until tomorrow, basically. But they have until 6 o'clock their time to review 7 hours of video of Carmen, because they were saying either part of it comes in or I'm sorry, they were saying if you're going to let part of it in, then they want the whole thing to come in. So the final, I guess, verdict, if you will, on all of that is that live court is done for the day. They're going to pick up tomorrow. So what we're doing, and tomorrow's is going to be all about Detective O'Driscoll. And he's going to bring in walk the dog letter, among other things. He's going to bring in testimony, statements from Carmen, statements, jailhouse calls, statements from Kouri. So what we're doing today is, instead of ending at 1:30 or 2, whenever it was, we're going to review these 2 hearings that are very pertinent, that have to do with rulings on walk the dog. So we've got maybe another hour or so to go, and then we will be done with that for today. All right, so let's continue on.
Tell me if you see it the same way.
Okay.
So, initially, the only thing the state has to show is is the materiality of the information requested from the defense before the defense is required to either make the information available or assert a constitutional privilege, such as one against self-incrimination, an evidentiary privilege, such as the attorney-client privilege, or a counter-argument that you're wrong, it's not material. Why aren't we at that point where you're saying, for example, it's privileged, maybe additional privileges and arguments will be raised in the briefing that would occur behind seal, such as what they want would implicate Ms. Richins' right against self-incrimination and or it's not material. That's what I'm trying to have play out through the adversarial process, and I don't know what's in the document.
Right. I think perhaps the state needs to make a good cause showing that they're entitled to it, I think, before we get to whether the materiality of it.
I think that's where we differ, and the reason I say so is, and I'm happy to be educated about this, but State v. Spry, 2001, UT App 75, we further hold that the good cause, quote unquote, under Rule 16c requires the prosecution to establish only the materiality of the information requested from the defense before the defense is required to make such information available to the prosecution. But also that things like the right to the privilege against self-incrimination is paramount and therefore overcomes that good cause consideration. The state in its motion is saying, we think there's good cause here because based upon our interpretation of the content of the jail calls, this is a factual, partially factual narrative. Therefore, it's material. I don't know if that's true.
If that's the court's position, they've only made that as it relates to the 60 pages, not the entire packet.
I agree.
So,
are we talking about the entire packet?
Well, it was unclear to me.
Mr. Nate says yes.
Yes, I was asked to turn over the entire packet.
Is that accurate, Mr. Bloodworth? I thought the briefing was I agreed to turn over the 60-page document, and then upon reflection, I can't do that anymore.
It was further requested that I give the packet to the review attorney, and the problem with that.
Mr. Nate?
It's okay. You're.
I apologize.
The problem with that is I can't. Once I assert a privilege, I can't turn it over or I waive the privilege,
Understood.
and I can't turn over a part of it. So. I guess what I need from the court today is an order telling me I need to turn over the 60 pages. If that's what the court's inclined to do.
No, I'm inclined to not do that.
Well,
so let's take a step back. I understood, Mr. Bloodworth, that we were talking about the document, not the folder.
Your Honor, there's letter number 2.
So that's the one she held up?
Which is the one she held up.
Okay.
And then 60 or so pages of what she describes as the continuation of the walk the dog fictional narrative.
Okay. Are those the two documents we're talking about?
Yes, Your Honor. We don't know what else is in there to make a good cause showing.
Well, that's the way it goes, though, when people are handing an attorney-client privilege or a marked folder their attorney.
Well, yes, Your Honor, but when removal of the material from the jail violates jail policy, that adds another wrinkle to it.
Let's stay focused on the two documents. I don't have enough to speculate about what may have been in or not in that folder, and now I understand the significance of Ms. Lazaro telling me jail staff went through the folder several times. Now I understand where you were headed with that. Let's stay focused on just the two documents. The one page that was held up, which the vernacular for that is letter number 2.
The vernacular is letter number 2, Your Honor. It was multiple pages.
Okay. And then the 60-ish page document.
Correct.
Why shouldn't we handle those two documents in the way the court proposes?
objection to that, provided that the court order me to give them to the review attorney or the court. I have no objection to those two documents.
Okay. Well, we're going to
long
need to put
as
an order in place first, identify who either the review attorney or the shielded representative of the state in this process is. And listen, I understand that normally the court would just review a document and make a determination about privilege. This case is very high stakes. It's an aggravated felony. It has enormous amounts of attention. I don't want to make this decision without the benefit of the adversarial process, so we're going to use belt and suspenders on this one. Have you determined, Mr. Bloodworth, who is going to represent the state in this process?
Your Honor, not by name.
Okay.
We can, but the state will select somebody in short order to serve as the state's advocate in this process.
I appreciate that. What I'm inclined to do is order counsel to meet, confer regarding the terms of an order that will control how this process unfolds. It states in black and white who is allowed to have access and not allowed to have access to the 60-page document and letter number 2, and then hopefully provide some deadlines for submitting the 2 documents to the state's shielded attorney and briefing deadlines for getting it before the court. Does that sound reasonable, Ms. Listener?
yes.
Mr. Bloodworth?
Yes, Your Honor.
That is the state's order. Can you meet, confer on that within 1 week?
I am, yes.
Or
it's
no?
not- probably not, actually.
Okay.
I'm gone. I'm going to be out of town working the majority of next week, and I'm on vacation the following.
How much time would you like to get this sorted out?
Can we go to maybe the beginning of December?
By December 1, I need a proposed form of order or competing proposed form of order submitted to the court.
And just so I'm clear today, the court's ordering me to,
Not disclose anything yet.
okay, until you have this.
Until
proposal.
the
Okay.
rules of this review are set, the participants are identified, those that cannot participate are identified, and that order's in place.
Okay.
Then everybody will know what they can and can't do.
Understood.
I think that's the appropriate way to handle this. Any objection, Mr. Glover?
No, Your Honor.
Okay. All right. That handles for today. The motion for good cause, motion to compel good cause disclosures. To be clear, I'm not expressing any opinion one way or the other about what's in this document, whether it's material beyond the facial, prima facie showing of good cause, or whether any other privilege would apply to it. I just don't know what's in it, and I need better briefing regarding the circumstances under which it was created, who it was provided to, things like that. Okay. I think, Ms. Lazaro, Mr. Bloodworth, that brings us to conclusion on the motions that are pending in the criminal matter. Is that correct?
Yes.
Okay. Mr. Bloodworth?
Yes, Your Honor, to the extent the motion to compel is concluded.
Well, it's concluded for today.
For today.
Yeah. All right, very good. Let's turn next to the probate case.
Switch spots. Your Honor, perhaps before that, can we discuss scheduling in this matter? I think that was part of today's initial agenda.
Yes, that makes sense. I can appreciate why you wouldn't be comfortable having this matter not have a next scheduling conference, but there's a lot to be worked out on some document discovery issues. Ms. Lazaro, what do you propose?
I think my proposal would be, let's get this order in place with the timelines and then schedule dates accordingly at that time.
I'm comfortable with that, Mr. Bloodworth, if you are.
Yes, Your Honor. Do we want then to get something on the calendar, perhaps mid-December?
Well, I think part of the court's order was that in our proposed order, we come up with deadlines and then
For briefing,
For
that'll
briefing.
drive
that'll drive the next hearing.
my consideration, and then there will be a sealed hearing, I imagine, to hear from counsel's argument and make a ruling.
Okay, Your Honor, then we can perhaps
Yeah.
meet, confer, and propose as part of that.
That would be my
scheduling
preference.
day.
Yeah.
Yes, Your Honor. Understand.
That works.
Anything else?
If you don't, please let me go around after. No, sir. Thank you.
Okay. All right. Very good. The probate man, Mr. Hinton. No, not Mr. Hinton. Mr. Hinton this time. Let's begin with the motion for preliminary relief under the Slayer statute in case 223-500-019. Can I have counsel for the trustee and the estate make their appearance, please?
Yes, Your Honor. Your Honor. James Tracy and Jake Gorange on behalf of Kouri Richins Benson, who is the personal representative of the estate of Eric Richins and is also the trustee of the Eric Richins Trust.
Welcome to all of you, and then counsel for Kouri Richins in this matter, please.
Yes, Your Honor. Austin Nate and Sky Lazar on behalf of Kouri Richins.
Okay, very good. Mr. Tracy, let me ask you some practical nuts and bolts questions here. You ask for an order enjoining Ms. Richins from dissipating her property and assets, acknowledging that she will have some legitimate expenses that would need to be accounted for.
That's true.
You ask for an order imposing a constructive trust on her assets and requiring execution of a trustee's bond. I have a lot of questions about that order. And then appointment of a receiver to manage Kouri's property and assets, pending a determination of the estate's petition to establish disqualifying homicide. Talk to me first about the order enjoining Kouri from dissipating her property and assets. I'm unclear to what extent your three buckets of relief overlap unnecessarily or duplicate each other unnecessarily. The statute says what it says. You're entitled to some injunctive relief to maintain the status quo. Recognizing there's the abstract possibility that you would be able to prove a disqualifying homicide, we do need to make sure, though, that I do not inadvertently prejudice Ms. Richins' ability to provide for her defense. How you recommend we do this as a practical matter?
As we put forth in our briefing, Your Honor, we don't object to payment of expenses for her defense on three conditions. One is that they're reasonable. Two, that they're approved by the court and or a receiver. And three, that they not come from life insurance proceeds or other assets that were Eric's that she wrongfully took. Now, we don't know that we don't have a clear picture of all of her assets.
Pause there for a minute. Money is fungible. Her assets are X amount of dollars. Whether it comes from life insurance or it comes from encumbering real property or it comes from something else, what's the difference?
Well, I think there's a huge difference. Now, again, I'm just looking at the allegations in the information, also the briefing and the detention hearing and the evidence provided.
Sure.
Looking at those things, it appeared that the state had sufficient evidence to establish that Ms. Kouri Richins was in serious financial trouble, and that she had access to millions of dollars of life insurance on Eric Richins' life. Using those facts, it doesn't seem unreasonable to think that most, if not all, most of, or a substantial portion of liquid assets that she had, cash, could have come from life insurance. we think that the court has broad discretion under the statute to preserve the assets of, it says the killer or the killer's estate. I'll just refer to it as alleged. Okay, so we know what we're talking about, but I don't want to upset the defendants on this matter. But it seems unfair to us. The whole point of the statute is that a person not benefit from the acts covered. And
I agree.
If you get life insurance and then use it for your defense, it seems that you're doing exactly that.
Now, how are doing exactly that if you use other marital funds that did not come from life insurance? Why is life insurance more worthy of protection than other marital funds?
Well, I don't know that it's coming from other marital assets.
You don't know that it's coming from life insurance?
We suspect. We don't know. What we know, apparently, there's facts that show that she was upside down in many areas, but we don't know what money she had from her real estate business. I don't know. But we don't. This is really going to be work that we think is appropriate for a receiver.
How would we structure a receiver's involvement so that with respect to approval of her defense costs, Ms. Richins had a clear route to make sure that the receiver was not impeding her ability to fund her defense?
It's very fact-intensive, Your Honor. If the receiver, hypothetically, was put in place and was able to determine that, for example, let's pick a number. Let's say there was $3 million of life insurance, or $2 million, whatever it was, and that all of that was given to her defense counsel for defense. I think you would have to know what they anticipate the reasonable cost of defense are.
I'm asking more of a procedural.
Is she stashing money with defense counsel?
Please don't talk over me.
Oh, I'm sorry.
I'm asking more of a procedural question. What if she disagrees with the receiver's determination of what's reasonable? What's her relief?
Your Honor, we come to Your Honor.
You can imagine how much I don't want to be approved of Ms. Richins' defense costs.
Yeah. I'm not sure how else we do it.
That's okay. Thank you. All right.
Your Honor, the statute, it contemplates sort of a wide range of options. And by the way, I noted in preparing for this hearing, this section of the statute is just a little over 2 years old. Section 8, which we're dealing with, was put in effective May of 2022. And so under this statute, and it specifically says before the court determines whether there's been a disqualifying homicide, then the court can enter a temporary restraining order, an injunction, to preserve the property or assets of the alleged killer, or the trustee's bond, or a constructive trust, or any other action, which we think would certainly include a receiver under Rule 66, which is pretty broad as well. Under Rule 66, the court may appoint a receiver in any action in which property is in danger of being lost, removed, damaged, or is insufficient to satisfy a judgment, order, or claim. Now, in this case, Your Honors, we put in our moving papers, and since then, in the month of September alone, 4 properties were foreclosed on that were either in
notices of default where did foreclosure sales actually occur?
There's been additional notices of default, but in the month of September, 4 properties actually were foreclosed on.
Meaning?
That had notices of default and there were trustee sale.
Okay.
So there is property being lost right now. I don't know what efforts, if any, are being made by Kouri Richins to try to preserve those properties. We don't know what equity, if any, were in those properties. But we do think that this is an appropriate case for a receiver. Exactly what the scope of the receiver's responsibilities are and the authority to make determinations as, for example, reasonable defense costs, I think we're going to have to work through that.
Talking about the constructive trust, typically, right, constructive trust is a equitable remedy imposed after some transfer has occurred to claw it back or provide a notice flag in the sand, however you want to look at it, to say this is going to be coming back in this direction in the future. How would it work here? In this trustee's bond, the way you've talked about it, it would be money posted by Ms. Richins, but you don't want her to have access to any of her money. You can see why I'm confused.
Yeah, well, it is confusing. Typically on a constructive trust, as you mentioned, Your Honor, it's a situation where someone has money that under the circumstances, using equitable principles, the court will order that that person is holding the money in trust for another person. So in this case, the way it would be applied is when you have a killer, an alleged killer, that person's assets would be determined by the court to have been held and are being held for the benefit of the decedent's estate, whatever they are.
And that order gets recorded against each parcel of property titled in the name of Kouri Richins.
If it's property, perhaps you would record the order. If it's other assets, they're just deemed to be held in trust. And then I guess if there's transfers out, then potentially what you have is a breach of fiduciary duty because they were being held in trust.
How is this better than the claims for fraudulent to transfer the aborting bond? Or maybe reference. I looked at the complaint. It wasn't clear what it's saying. You were actually bringing claims under the Fraudulent Transfer Act versus other causes of action.
Well, there are claims for avoidable transfer, Your Honor, relating, I think, primarily to real property. But as I read the statute, they are giving a court the ability to establish a constructive trust on any property or assets, not just real property, any assets, to preserve those for potential claim by the decedent's estate. I mean, granted, constructive trusts are a little hard to get our arms around because it's kind of it's imposed by order.
Well, the statute doesn't talk in terms of constructive trust. It just talks in terms of trustee's bond, right?
No, it says establish a constructive trust on property.
Yeah.
And then you can also require an execution of a trustee's bond. Now, I can tell you how trustee's bonds typically work. It wouldn't work in this case. If you have says Kouri Richins shall not dissipate her remaining assets, that ordering that there's a constructive trust imposed as of the date of Eric Richins' death on all assets, and appointing a receiver to manage her remaining assets.
The terms of that receiver appointment would need to be worked out.
Yes.
And correct me if I'm wrong, I didn't see a proposed appointment order in the briefing order. Did you worked out those details?
We have not. We would want to get with opposing counsel and see if we can work out an agreement.
All right. Let me talk to counsel.
Thank you, Your Honor. It sounds like you may have some specific questions that you'd like me to address right at the outset on this.
The difficulty here, to say the quiet part out loud, is the legislature drafted a statute with policy in mind. So I can't take the position that this is never enforceable. It says may, so it's not required, but I think it would be an abuse of the court's discretion, or the word may, to take the position that I don't have to do this, so I'm not going to. I'd have to make some findings about why it's inappropriate in this case, and contend with the either explicit or implicit policy decision made by the legislative branch that this is the type of thing that should occur in a case involving a potential disqualifying homicide, which this is. How do you recommend the court navigate those waters?
I think it's a fair question, and frankly, some of the questions that the court has, asked today, or some of the questions that we've been asking ourselves, is just the practical implications, or how you practically actually create a situation where this makes sense. I think is extraordinarily difficult. And just to add to what's already been discussed, I mean, if we're talking about a receiver over all the assets, I think that would necessarily also include, or typically does within a receivership, causes of action that are held or pursued, which would mean beyond clarification. Right, so I guess if that's a way to carve that out, and then to the extent that there's a recovery in those cases, does that also automatically become part of the receivership estate? I mean, all this to say, I think that this will expand the scope of litigation substantially. I think that you will be, the court will be, substantially more involved in this than perhaps what it would like to be, or what is necessary, or really what is prudent for judicial efficiency purposes.
Right, but come back down to the specifics. Yeah. My biggest concern is inadvertently prejudicing Ms. Richins' financial ability to fund her defense. That implicates constitutional concerns that seem paramount. Is there a way to sufficiently fund her defense, but otherwise prevent dissipation, maintain the status quo, protect assets?
We don't believe so, Your Honor.
But why?
I guess perhaps there could be a way to craft that, but again, we're talking about substantial amounts of time, energy, and expense to actually figure out what that's going to look like. And so that in and of itself, going through that process of figuring out how we're going to fund her defense, we're going to deplete resources that would have been allocated to the defense in the first place. Does that make sense?
Sort of. Can we agree that I'm not going to ask you what her assets are, and I don't think it would be appropriate for me to put you on the spot about her right now, but do you know what her assets are?
Generally, I would say yes. Specifically, I would say no.
I have no idea how the legislature expected a judge to make this decision without asking all kinds of questions that I really don't want to ask.
And I think just to add to that, Your Honor, particularly in a case that is as much publicity as this case has, if we get into the injunctive relief, and this is in the briefing, that sort of thing, right? Whether that requires some sort of a finding of substantial likelihood.
Yeah, pause there for a second.
Yeah.
Isn't the easy button on that just to say, as a matter of law, this court rules that the substantial evidence determination is sufficient to satisfy Rule 65A(e)(1), and just stop talking about it?
I mean, certainly the court could do that. I think those are two different standards, and I think we would take the position that for a preliminary injunction, that may well be a higher standard. We obviously haven't gotten into that a great deal in the briefing, but from our perspective, we think it is a higher standard, and obviously the substantial evidence, at the pretrial hearing, probable cause still hasn't been shown, and I'm not trying to equate probable cause with what substantial likelihood of success in the marriage looks like, but perhaps there's evidence. Yeah, or substantial evidence. So it is convoluted, and it does make it a little bit tricky, particularly taking into those considerations as well.
Would you acknowledge, though, that in general terms, this kind of case is the kind of case that is targeted by this statutory provision? That is, a situation in which, if a defendant is found guilty beyond a reasonable doubt, or in a civil matter by preponderance of the evidence for a disqualifying homicide, loses any interest in all of those assets?
Yes.
receiver. I'm not sure that's better.
You're not sure that a receiver is better?
Right.
And I agree. I think based on the discussion that you had with Mr. Tracy, the practicalities of that is going to be very, very difficult to iron out, and what that looks like. Some of the additional practicalities that I've suggested here, and I think as well too. I mean, they've moved under Rule 66, but there's the Utah Commercial Real Estate Receivership Act, which comes into play when we have real property addition to receivership, and so that has obviously not been addressed, and I think would be implicated under these circumstances, so would need to be consulted and addressed as well. So, to the again, practically speaking, a receiver makes little sense. I think it makes the process significantly more cumbersome than what it already is, and so don't think that appointment of a receiver would make much sense at all under these circumstances.
Has the estate served Ms. Richins with any written discovery asking her to identify her assets?
In the context of the probate case?
Correct.
I do not believe so.
In the context of any other case?
I don't think so.
Okay.
And I could be wrong. There's several cases, obviously, and lots of written discovery, but I do not believe so.
All right. Okay, let me ask Mr. Tracy some more questions.
Thank you, Your Honor.
Mr. Tracy, what's the irreparable harm here? There are other tools available to the estate to identify assets in the flow of money, to trace the flow of money, to provide notice to potential bona fide purchasers or other transferees, and to claw back assets. Money in many ways is fungible. Why is there irreparable harm here if I don't put any injunction in place, but allow you to start figuring out through the discovery process the answers to the questions you don't currently know the answer to?
Well, first of all, Your Honor, typically in civil litigation, we're not allowed to inquire as to a defendant's assets without a judgment. In this case, because
this is a little different.
I know it is, but I guarantee in some of the, like for example, the civil fraud case, they're not going to answer questions about what her current assets are. In fact, they moved to stay the case, which you'll hear here in a minute from my partner, Mr. Kouri.
Right.
Let's talk for a second about, and by the way, in the estate case, we did demand an inventory. As part of the inventory, we asked for disclosure, but we haven't gotten a disclosure. But it's something we can follow up with motions in the estate case. But I do want to be clear, and I think you asked a question about Rule 65. As we put in our briefing, it's not clear that Rule 65 applies to paragraph 8A, 75-803, sub 8, paragraph A. It certainly does on paragraph B, but that only applies if you're seeking an injunction without notice or an opportunity to be heard. We don't concede that Rule 65 applies, and in fact, in preparing for this hearing, I'm more convinced that it doesn't, and we could submit briefing on that. I think the legislative history will show that Rule 65 was inserted only if you want a injunction without notice or an opportunity of a hearing. Under subsection 8A, no mention of Rule 65 is made. So I don't think that we're subject to the substantial likelihood of prevailing on the merits. But we addressed it in our motion in this way. Even if we were subject to it, we meet the requirement. And to that, I would, in addition to your rulings in the criminal case, we had 45 facts set forth, cited by evidence, and they didn't dispute it. They relied on her Fifth Amendment right, which she has the right to do, but in a civil matter, it comes along with an adverse inference.
Sometimes the law, that's a little more complicated than
well, she didn't rebut any of the facts. I don't think we really have a problem meeting the standard under Rule 65, but I don't think it applies technically.
This is why I'm asking you about irreparable harm. Why is injunctive relief necessary here? What about the status quo can't be either compensated in the future in money damages, preserved through other means, better characterized. I mean, just because I don't grant the motion today doesn't mean I can't grant the relief.
First of all, I don't concede that you can't get an injunction only when your damages can be compensated through money damages. Because there are circumstances where you just will practically, you'll never recover the money. And I will mention, what if there's nothing in 75-803 that carves out an exception for attorney's fees, by the way. And in every case where you have a disqualifying homicide, you're probably going to have a murder trial. I mean, more likely than not. So I don't know that the legislature was concerned about how do we carve out defense costs. When we prepared our motion,
the Constitution might be concerned. I said the Constitution might be concerned.
Which is why, in our motion, we specifically stated we're not seeking to prohibit her from having reasonable defense costs. I just make a note for the record, there's nothing in the statute that carves that out. Again, you have a variety of things in the quiver here that you can use to address this. Just imposing a constructive trust seems contemplated.
Why not?
And I can't see why not to do it.
Why not freeze? Enter an order freezing her assets in their current state of title, meaning can't hypothecate any of the assets out of current states of title. If they're titled in the name of Kouri Richins, they stay that way until further order of the court. If they're titled in the name of
K. Richins Realty,
you think I can reach that entity since it's a single member LLC?
We think so.
She'd be the human being that would be acting on his behalf. So if they're titled in the name of KA, or they stay that way. If there are funds in a bank account, they stay in the bank account. And then press pause and let you all get me better information about why you think this will or won't work. You're asking me to shoot in the dark here.
Because we are in the dark.
I know, but if you'd serve some discovery, we'd all be better off. And now there may be reasons that it hasn't happened yet, but I'm just saying there are tools available. What do we do about the fact that her properties, or properties titled name of KRR, have notices of default?
Well, it's going to take an analysis of whether there's enough equity in there to bother trying to rescue them. But
presumably, Ms. Richins has an equal financial incentive to do that, right?
Depending on the amount of equity in them.
Sure.
If it's only $20,000 of equity, maybe not. With regard to your suggestion, Your Honor, we would welcome, and certainly we would welcome and take from the court a freeze of her current assets. I think in addition to that, I would ask the court under 75-2803 order that the constructive trust on any property or assets of Kouri Richins was effective from the time of Eric Richins' death. What that means exactly, I don't know. But I'm just telling you, I mean, it should be a constructive trust. What that means as far as the consequences of that, I don't know until we know what she did with the assets.
I'm not opposed to that concept in terms of at least casting a net that goes back in time. How would I structure that constructive trust to have an exception for assets that have been used or would reasonably be used to defend herself?
Here's what I think one way this might work. The court's order could say freezing all of the assets as you just mentioned as of today and going forward. Now, in addition, the court, pursuant to this section, orders that a constructive trust, or that all property or assets of Kouri Richins is subject to a constructive trust in favor of Eric Richins' estate from the time of Eric Richins' death. Period. I mean, it's up to us to decide what we do with that. And here's what I would say. If then, after we find out more about what she's done with her assets, if she made what we think is an unreasonably large transfer, far beyond maybe what was needed for reasonable defense costs, then we would argue that that was a breach of our fiduciary duty.
Nice.
They would argue it's not, and they would tell us why it's not. I don't know how that would turn out. But I think under the statute, it's fair to say, if, in fact, she's guilty, we don't know if she'll be found guilty or not. But if someone's found guilty of a murder, it's certainly not unreasonable that any of their assets from the time of the death of the victim forward were held in constructive trust for his or her estate. That seems pretty reasonable.
And so the parties would have their respective arguments about whether expenditures since Eric's death to now were within or outside a proper exercise of Ms. Richins' fiduciary duty.
Yes.
All right.
That's what I think.
Okay. Thank you. Let me ask Mr. Gates some more questions. So, Mr. Nate, let's focus on those two things.
Yeah.
In order, freezing the assets as they stand today, no hypothecation of any benefit transfers with for or without value, and establishment of constructive trust with the parties reserving your arguments about whether any distributions, use, transfers of assets to date were equitable, appropriate, within a fiduciary duty outside of it. You wouldn't be waiving any arguments in the future to say, Judge, this is too restrictive, you got to loosen it up so that she can defend herself. You would maintain the status quo. It would honor at least some of the intent of the statute. It would protect the estate of Eric Richins. Not as specific as I can be, given what I know right now. What's your response to that?
I think first and foremost, obviously, our position is that no relief should be granted and that the court has, discretion under the statute and should deny the motion. To the extent the court is inclined to do anything with respect to this motion, I think the relief that you just laid out is would probably work and would probably be fine.
At least for now.
For now. For present purposes, yes.
Okay. All right. I appreciate that. Anything else on this?
No, Your Honor.
Mr. Tracy, you're entitled to the last word. Is there anything else?
Just, Your Honor, I think that in an order that you might issue, we should make clear that we're allowed to proceed with discovery on her assets. But again, I know you've got a motion to stay that you're going to hear, and that can be part of the decision on that as well, I suppose.
We'll get there.
Thank you.
Okay. All right. The issue before the court is a motion brought by the estate of Eric Richins for preliminary relief under Utah Code 75-2803, subsection 8A. The estate requests an order enjoining Kouri from dissipating her property and assets while also acknowledging that Kouri Richins will have legitimate expenses, such as the cost of her legal defense in the criminal matter. The estate also asked for an order imposing a constructive trust on Kouri's assets and requiring execution of a trustee's bond. And the the estate asks for appointment of a receiver to manage Kouri's property and assets pending a determination of the estate's petition to establish a disqualifying homicide. The motion is granted in part and denied in part as follows. First, to the extent that the four factors under Rule 65A(e) must be met before the court may impose injunctive relief under 75 to 803 subsection 8A. The court finds they are met in this case for the following reasons. With respect to factor E1, the court finds that factor is satisfied as a matter of law by the court's determination that there is substantial evidence supporting the aggravated murder charge in this case. Regarding factor E2, the court acknowledges that the difficulty of recreating, chasing, and reversing any flow of funds or dissipation of assets that might occur during the pretrial period in a criminal matter poses an irreparable challenge to the estate in terms of maintaining Kouri Richins' assets for distribution to other parties in the event she is found to have committed a disqualifying homicide. Court determines under factor E3 that the threatened injury to the estate outweighs the damage to Kouri Richins that a carefully tailored injunction would pose. And under factor E4, an injunction is not adverse to the public interest and in fact is consistent with the public policy put in place by the legislative branch when it passed section 75 to 803 subsection 8A. Having determined that some form of injunctive relief is appropriate, the court is nonetheless concerned that an overbroad injunction will be constitutionally infirm because it will unduly burden Ms. Richins' ability to fund her criminal defense. And to avoid that prejudice to Ms. Richins, the court determines that a limited injunction in the following form is important and appropriate. First, the court is hereby issuing a preliminary injunction that hereby enjoins Kouri Richins from transferring, changing the title of, or otherwise hypothecating any asset that she currently holds or controls, or that her realty company, KRR, currently holds or controls. Second, under subsection 8A(3), the court hereby establishes a constructive trust on all property and assets of Kouri Richins and KRR Realty. The constructive trust is effective from the date of Eric Richins' death. The court will consider in the future as necessary arguments that transfers or disbursements of Ms. Richins' assets to date or in the future are reasonable and necessary to fund her criminal defense. And the court recognizes that exceptions to its order enjoining any transfers or changes in her current asset titling or holding may be necessary for that purpose, and exceptions to the constructive trust may be necessary for that purpose as well. The court is not imposing the requirement of a trustee's bond. It is not appointing a receiver at this time. The court denies those requests without prejudice. Mr. Tracy. I need you to take what I said and make it look good on paper. I need you to run it by Mr. Nate for his objection or approval.
We will do that.
Okay. Mr. Nate, any questions?
No, Your Honor.
Mr. Tracy, any questions?
No, Your Honor.
All right. That brings us to related motions to stay, the probate case and the wrongful death case pending the outcome of the criminal case. That briefing has taken some twists and turns. Mr. Tracy, Mr. Gorringe, what is, pardon me, I'm doing this in the wrong order. Mr. Nate, Ms. Lazara, what is the scope of the stay you're currently requesting in those two civil cases?
So, again, just to be clear, with all the cases that are going on, we're talking about the probate case and the trust case, correct?
I may be using different vernacular than you use. I apologize. So, what I have been calling the wrongful death case is 262.
Okay.
And then the probate case, I think, is 019, the estate case, right?
Correct.
Okay.
So, with respect to the wrongful death case, do you want me to come up to the...
Wherever you're going.
Yeah, I'll go ahead and come up there. So, with respect to the wrongful death case, there are some preliminary discussions with what a stay might look like. The plaintiffs in that case, or the plaintiff in that case, the estate, has agreed that some form of a stay is, that they don't object to it. But we haven't really been able to reach an agreement on that. And from our perspective, we think the overlap with the wrongful death case and the criminal case are so substantial that we maintain a position that a complete stay on that case is necessary and what we're asking for. So pause there for a second. Okay.
I don't know if this is accurate, but I think it is. Imagine, though, for the purposes of the hypothetical, that the wrongful death case ending 262 includes some avoidable transfer causes of action. Why should they be able to go out and try and claw back some assets, get them back into Kouri's estate? They would need, maybe they wouldn't need testimony or admissions from Kouri to do it, but if they asked for it, you would have your right to object based upon Fifth Amendment grounds or others. But why would I state that?
So, I think, to make sure I'm understanding the question right, is the idea here that perhaps you stay some claims and allow some claims to move forward, correct?
Right. There's a lot of claims. I mean, this gets messy fast.
Correct. And I think just from an overall or an overarching purpose, as we've stated in our pleadings, piecemeal litigation associated with pursuing some claims, not pursuing other claims, I think undermines judicial efficiency. I think it's unclear at this point. Do I think that there's some potential that voidable transfer claims could be implicated somehow in the criminal trial? I think it's possible. I don't have specifics on that right now. But you add that to the already very substantial allegations that are overlapping between the two cases, and I mean, we think that certainly would lend itself to staying the case in its entirety. And again, to allow the whole case to move forward at once or to stay the whole case in its entirety. And I think that, supports judicial efficiency. It also avoids unnecessary duplication of work, as set forth in some of the cases that we cited in our briefings.
What about the 019 case, the in re estate of Eric Richins? Why would we say that?
So, and again, just the verbiage that we've used on that is either the estate case or the probate case to make sure we're talking about the same one.
Yeah.
So, we filed a motion to stay in that case. You'll note from our briefing, though, on the, I think it's in the reply in the 262 case, I don't think, and we take the position in the papers, I'm not sure that Kouri has the ability to stay collectively the administration of the estate, right? I mean, and that's why we point that out. And so our motion to stay in the context of that case was narrowly tailored to, one, prevent, staying any action with respect to the petition to determine disqualifying homicide, which for obvious reasons, right? And then any other aspects of that case that would require the active performance of Kouri or anything that would require active performance in some aspect of the administration. So I don't think that case should be stated in its entirety. We haven't taken that position. Hopefully we've made that clear through our briefing, that it should be narrowly tailored to, the aspects of the state administration that implicate Kouri, including the petition for disqualifying homicide.
Do you acknowledge that proportional discovery in the estate case might include identification of Kouri's assets, where they are, where they went?
Particularly in light of the court's ruling today, yes.
Okay. All right, that's helpful. I appreciate that. Thank you.
Perfect. And then I guess I will just add as well, we have the original case that was filed that ends in, I think, 7-6. That one.
There's no briefing in front of me on that case right now, is there?
So there's still a motion to stay that's pending in that one as well.
I apologize. Okay.
So I'm happy to discuss today. If you would prefer to defer, that's fine.
I guess that's it. That's a hard. We just crashed. We just totally just crashed. So that's it. That's all they have. That's all they have on that channel. And I was just about to say, hey, Dina. Hello, Dina and Dreamhorse. I was typing hello to you guys, and that was an abrupt end. It was like, no warning whatsoever. So, all right, well, that's not a bad thing. It's a little bit after 5 here on the East Coast. We'll wrap it up then. Awesome, you guys. 303 likes. Love it. 568 people watching. I love it, love it, love it. Thank you. Really appreciate your support. Thank you for hanging out with us today. Weird day, but just to recap briefly, they were going, okay, so Detective O'Driscoll was scheduled to testify today, and we knew going in that both sides had to hammer out his evidence that he was going to bring in, which was going to be the jail calls, testimony from Carmen, walk the dog letter, and as they're going through that, everything seemed to be going fairly smoothly until we got to Carmen. And then the defense is like, wait a minute, state's going to cherry pick what they want to come in. We don't like that because we're not going to have a chance to cross because she's not on the stand. So if you're going to allow some of her testimony come in, or her statement, I should say, from jail, because they feel the law enforcement was leading Carmen to give answers and stuff. So if you're going to allow some of that to come in, you have to allow all of that to come in. And they went back and forth and back and forth and back and forth. There was like 2 or 3 breaks. They probably wrangled for about an hour or so. And it was like 1,000 pages or 7.5, 8, 9 hours worth of her statements while she was in jail. So back and forth they went. Ultimately, they said they asked for a continuance, a 2-day continuance. Judge is like, no way, that's not going to happen. So then they asked for a 1-day continuance, and he's like, okay, how about a half a day? So essentially, I guess he did give them a day continuance technically, because they didn't have. Well, no, that's not true either, because they did it. Then the state called in. They did call in a recall witness, the digital expert Chris Kotodemus. Kotodemus. Sorry if I mispronounced your name. So anyway, the upshot of all of that was court ended at like 1:30. The defense has until 6 o'clock their time to go through what they want to have redacted or added. And then they have to file that in a motion all by tonight. And then they're going to show up tomorrow at 8:30 and hash yet again more stuff. Jury is not going to show up until 1, and this is all local time, so that's 3 o'clock our time on the East Coast. So they're scheduled to show up at 8:30, and then the jury isn't scheduled to show up until 1. So they could be done in a half an hour, or they could go 3 or 4 hours. I don't know. We will be watching starting our time, which would be 10:30, but we come on 15 minutes early. So in the meantime, we decided to show some preliminary hearings, and they actually ended up to be pretty good. It was the 2 correction officers actually locating the walk the dog letter, and that was with Miss Lewis. So we saw her in action. That was from January of 2025. And then we saw we just finished with 2 parts of one hearing. One was with Sky Lazaro, who was Kouri's previous attorney, and this was from November of 2023. And again, they were talking about the admissibility of this walk the dog letter. And then the second half of that was Kouri's funding. How is she going to fund for her lawyers, for her defense team? So pretty interesting stuff now that we know the players, and we've heard them talk on the stand, specifically Katie. And we saw Mr. Gabler there in the gallery. So it was kind of fun to have this moment. I mean, it's not fun. I wish live court had continued, but if it was going to go off the rails like it did, it was nice to have enough time that we were able to show some pretrial hearings. So anyway. All right, Grampy, don't go anywhere. I got Super Ball. She's hanging out. So with that, I will say thank you for joining us today. Grampy, I got your girl right over there with her little tail. Oh, yeah. Hi. Oh, she's even going to get up for you. She's going to get up for you and say hello. Hey, come say hello. And then we got a couple kittens over here. Yeah. Hey, come over here, dude. Super Ball, don't sit on my keyboard. Don't smack the kittens. Don't do it. Come here. Hey. Yeah. Hey, no, don't. No, she's standing on the keyboard. All right, if I end the stream, it's because Super Ball is I went to Jules, that's why. Okay, so she kicked me over to Jules. See, that's what happens. That's what happens when you got this little one. Hey, look up here. Look up here. Over here. Yeah, I know. Come over here. Look over here. Doo-doo. Yo. Oh, big yawns. Yes, that's a good girl. That's a good girl. All right. So with that, thank you guys for spending your day with us. I really appreciate it. Oh, did she mute me too? Am I muted? Oh, I went over to another screen. Am I muted? Am I muted now? Oh, big yawn. Okay, I'm not muted yet. Thank you for spending your day with us. Thank you to our mods. Thank you to Aaron. Thank you to Super Ball. Thank you to everybody that is supporting our channel in whatever way, shape, or form you see fit. Whether it's just hanging out with us, whether it's buying merchandise, sending us Venmo, buying gifted memberships, buying our merchandise, however you guys support us, we really appreciate it. And most of all, just spend your day with us. We really appreciate that. Giving us likes, we have 312 likes now, so even better. And with that, we'll see you tomorrow, 10:15 Eastern. 10:15 Eastern, we're going to start tomorrow. So take care, guys. We'll see you then. Bye.